I practice out of Indiana. I also have an interstate law firm in Florida, and we're doing most of our litigations in Florida, frankly. I've been a member of the bar. My first 2 years were in Riyadh, Saudi Arabia. And you say, wow, why were you there as a woman? My ex-husband was Department of Defense, and I worked for the largest law firm in the Middle East. And there we represented most of the major banks, Citibank, Chase Manhattan Bank, Deutsche Bank, I think most of the major banks, and corporations. GMAC at the time GMAC was the big financing company there. So I've kind of worked for the banks, as you say. So if you think about my current website, suethebanker.com, it's a little different. I then went 6 years to Washington, D.C., where I was a lobbyist, and I also did securities offerings. So Atlas Van Lines, I did that securities offering. MetroCall, at that time was known as First Page. It merged into MetroCall. I did that securities offering. So I also have a background in securities work. 12 years private practice. This is after I had my daughter. I couldn't do the corporate thing, so I opened my own firm and I was in litigation work. All I did was courtroom work. Maybe 3 out of 5 days I was in a courtroom, and that's what I did. About 9 years ago, I said enough of that. How many of you are litigators in here? Yeah. Anyone say enough of that sometimes?
Sometimes.
Yeah.
Every day.
So enough of that. I thought I could work smarter, not harder. And I went into real estate investing almost full time. And bought a lot of commercial properties, bought a lot of lease option homes, things like that. Got back in, or I also developed, I did development work. We had a 348 unit multifamily. So I know a lot about real estate too. I am a licensed real estate broker in Florida. I am a licensed mortgage originator. They've changed the name, as most of you know, under the new, what is it, NMLS, which is now nationwide type of thing. I am a licensed mortgage originator in Florida. And I started National Note Association. So National Note Association is a company that buys and sells mortgage notes, and I started doing that 6-7 years ago. So I've been on the other side. So not only I've been in banking, I've been in securities work, I've been buying and selling mortgage notes where if you didn't know about a mortgage, you could lose a lot of money. So I learned a heck of a lot about mortgages. I still invest in mortgage notes. And probably as we go, I'll tell you a little about that and how it, sometimes, I was just saying that the last mortgage note I bought, I'm in the middle of foreclosing on it because I actually will represent, I'll actually represent both. I have a lot of homeowners that we represent, but for my personal thing, I do the foreclosures. We don't represent any banks within my firm, but I do foreclosures on my personal notes. So I kind of know both sides of the aisle, and that actually helps. The last note that I bought was transferred 3 times by MERS without it being back to MERS. So obviously there's a problem with chain of title, and you might ask, why would I buy a note that was transferred 3 times by MERS? Isn't that a problem? Well, the guy filed bankruptcy, and he never reaffirmed it. So to me, that was a fairly safe investment. He didn't want the property anymore, and for $12,000, I could buy an $80,000 house. Do you think that's a good investment? I think so.
Yeah.
So, yeah. So I'm in the middle of foreclosure on that, and it was about $12,000. I've already got a contract on it to sell it for $35,000, the house. So after I'm done with the foreclosure. So if you want to talk about mortgage notes at all, I love talking about mortgage notes, but that's one of the reasons why I understand this so well. And with the securities work as well as the banking work, that's where we go from here. Right now, my firm in Florida has about 70 cases going, which is foreclosure defense, some of it, where we are countersuing for quiet title based on the securitizations. Now, I have to say that there are some that we actually find that they did everything right. For example, I represent one investor. He's got 19 properties with us, and 4 of them were done right. You look at the paperwork, you look at the title work, I don't see any problems. And this is what I'll be teaching along the way is how do you look at all this, how do you figure out what's the issue. And on those 4, what we're trying to do is just do a principal reduction, some type of buyout of the note. We have investors that are willing to, and I don't know about you, but our alternative for our clients is to go in and actually try to buy out the note if we can. Now, in not all cases can we do that, because in not all cases will they allow us to do that. But if we show enough information and have other cases working with them, we're trying to get those involved as well. So that's me. Today, we're going to talk about achieving principal reductions with lenders by creating leverage. And why do I say that when we're talking about mortgage securitizations and quiet title? I do not want, and I hope you don't encourage your clients to say, oh yeah, I can get you quiet title and I can get all the liens wiped out. I always tell my clients that's the home run, that if you can hit that home run, more power, I hope we do. I hope we do. We even put a success fee in our contract. If we completely extinguish the mortgage, we have a success fee in our retainer agreement. And when we file for quiet title actions, what do we hope for? We hope for a default, and I'll explain why. But a default is still a good judgment, isn't it? As long as it's not set aside, or as long as you can prove service, etc. But in most cases, what we're going to be looking for is the principal reduction, because in most cases, what the homeowner wants, that you'll probably be representing as well, will be the fact that they want to stay in their home. Is that true for most of you? They just want to stay in their home. They know that it's a bad investment. They may be totally upside down. They may be at, let's say, a $400,000 mortgage on a $200,000 house, right? So that's the issue, is how can they afford to stay there? Most of their jobs, or many people have jobs that have been downsized. Maybe they're not experiencing, if they're on commission-based salaries, maybe their commissions have gone down a lot. So their ability to pay that $400,000 mortgage on a $200,000 house doesn't quite work out. One of the other things I'll probably discuss today is bankruptcy, because I frankly love bankruptcy courts, and I love when we can go in and litigate in bankruptcy courts. Do any of you do any adversary proceedings in bankruptcy court? Good. I like 3 hands. That's good. You may want to consider more of those, and that's particularly of the proof of claim. During the proof of claim, they've got to be able to prove under, what is it, Section 3001, that they actually own that note. And that's one of the things we'll be showing, is how to use the 3001 provision in the bankruptcy in order to, that's the point where you could actually do kind of a quiet title within the bankruptcy proceeding. So we'll talk about that as well. And then Oliver Hall, I want to introduce him. He's a New York attorney. He's doing a lot of foreclosures. CFLA invited him, thank God, to do the New York portion. I've tried to focus as much as I can on New York, and I have read a lot of your recent cases, thanks to Oliver. But he's going to go over some of the recent cases so that you understand. I love New York law, that I'm seeing anyway, because it leaves a lot for you to litigate. Now, in Florida, where we're doing most of our litigation, the biggest problem is that the court will say, you got the note, they got the note, right? They don't care about this chain of title problem. They just say, you got the note, they got the foreclosure. And we're fighting that tooth and nail. But it's still an issue. And most of you, what we keep saying is, where do the judges have their retirement accounts? Huh? Little conflict of interest if they're invested in mortgage-backed securities? Maybe. Do you think some of the retirement accounts, pension funds might be invested in some of these? Possibly. Do you think that they're recusing themselves because of this conflict? No. No. So a lot of the problem is, and we discussed this too, that we have a lot of pro se litigants. A lot of people, down on their luck, they don't have the money to hire attorneys. So they're trying their best to defend themselves, and that's pretty tough without the background that most of you have in here with with education. I know we've got some non-attorneys here, and that's great. But if you don't have that background, you know what you've been through. You know that you came out of law school going, okay, what's a pleading? What's this? What's that? How do I put it together? And these are people that have never done that for the most part, and they're trying to defend themselves. So that's where we also have problems, is that some of the law is not great because it's pro se. It's been done by pro se people. History of mortgage securitization. This is important because it's going to happen probably all over again. You almost see it happening all over again. They're starting to issue mortgage-backed securities already again. And you wonder, are we ever going to learn? Now, this happened back in 1933 when the Glass-Steagall Act required the separation of commercial and investment banking. And what did we do in 1999? We repealed that, basically. And then with the Federal Reserve dramatically lowered interest rates, particularly after the 9/11 incident and the dot-com issue, it kind of fueled that mortgage-backed securities then, because between 2001 and 2007, what did they figure out? They figured out how to make a lot of money on Wall Street with mortgage-backed securities. And that's both residential mortgage-backed securities, so you'll see those initials sometimes, the RMBS, and also commercial mortgage-backed securities. Now, those are two different things. And one of the things that you'll see is that in residential mortgage-backed securities, when you try to go in and buy out something, it's not that, they won't do that for the most part. Now, commercial, what they do is they just put a bond in there. So if you buy out from a bond, it's much easier for representing commercial clients because they will arrange to have a bond replace that value of the mortgage that you're buying. So when you're talking about buying out, think of commercial's much easier, residential's pretty tough because they just don't want to get into that kind of numbers game. Loan originators, I hold a loan originator license, and I'm always amazed. In Florida, it costs like $1,000. My renewal for my bar is what? For me, in Indiana, it's like $250 a year. For this new mortgage originator license, it was maybe $1,000 to get it started, and is that the same here? $375, but didn't that include all the new classes? And yeah, right. Didn't include all the new classes, and I spent almost $1,000 to renew based on this new SAFE Act and the new NMLS. But at the time, they like to blame all the mortgage loan originators. And I said, which mortgage loan originator put their money up and put their criteria up? Was it their money? Was it their criteria? No. But who did they blame?
We were using the same lines
Right. They were using, now if there was fraud, that's one thing. If that was fraud, that's something different. But for the most part, all they were saying was, okay, you'll fund a loan like this? Well, let me find the people that I can put in this. Right. If you didn't want if you didn't want income documentation, if it was a no-doc loan, that's what you presented. So they like to blame the mortgage loan originators, or at that time known as mortgage brokers in those states.
With all these rules
Now they have penalized the people that have done it because it's the rules are.
I'm saying with the rules and all these
kind of ridiculous.
Everybody going to
yeah. Well, what they basically have done have made it so that you almost have to go through a bank. It's very hard to beat a bank now as a mortgage loan originator. The only thing that I see mortgage loan originators doing are the Part 2, which is, as you know, where you can get a little bit of a principal reduction. But they like to blame the mortgage loan originators. And there was fraud, there was deceit, there was lack of accountability. And the biggest problem was that there was a lack of the attorneys and the Wall Street firms created all these trusts, but there was no follow-through. The people that needed to do the follow-through probably weren't trained the way they needed to be trained. So we'll see where all the gaps are. And that's the gaps of what they didn't do is what you as attorneys will be attacking, right? So if we have gaps here that they were required to do certain things under the Securities and Exchange Commission, because these are securities that we're talking about, and if they were required to do certain things under the IRS, because these are tax remote entities, REMICs, and they didn't do these things, then that's where you attack. You find their weaknesses and you attack it there. But we're talking about mortgage-backed securities, what they are. This is off of the Securities and Exchange Commission page. Debt obligations that represent claims to cash flows from pools of mortgage loans, most commonly on residential property. Mortgage loans are purchased from banks, mortgage companies, and other originators, and then assembled into pools. Thus, we have the pooling and servicing agreements, correct? Now, the pooling and servicing agreements basically create that security. And we talked about most are issued by Ginnie Mae, Fannie Mae, Freddie Mac, and the variety of structures. You can take a look at that at the Securities and Exchange Commission. Yes, sir.
Would you make a bigger than that?
I wish I could. That's what we worked on this for about half an hour. I apologize to those that just came in. At break, we're going to see if we can get the technical issue. I have a Mac, and for some reason this projector.
Not even the size was like blurry.
I know. I'm sorry.
So kind of blurry.
And
Blurry.
that is too large.
Oh,
I apologize. We'll see if we can get that fixed during the break as well, because it shows up full screen on mine, so I apologize. I didn't bring my projector, which normally. Okay. And it'll be up to CFLA. Maybe we can get a copy of this out to people.
Yeah.
I don't mind doing that if that's possible. We'll have to email you anyway with all the CLE information, so this won't be a bad thing. And we talked about the timing issue right here. If you can see in this chart, it's January of 2001. January 2001 when this really started, where the interest rates were coming down. Greenspan was doing his conundrum arguments, that it's conundrum that the interest rates are falling, but the other things were happening. You can kind of see in here, within this time period right here, this is 01 right here, and where the interest rates, this is the number of years fixed rate, and this is the number of refis. So you can see how particularly, this is in 03, how we had so many securitizations taking place during that time. Now, how many of you studied the National Mortgage Settlement Act? How many of you read the thousands of pages? You've studied it?
Not the whole thing, but I've read parts of it. I've gotten a lot of clients under the DOJ mod program, and and I've taken CLEs with Bank of America and other lenders that are not helpful.
Not helpful.
Not helpful. They don't know how properly to administer it either. So
have you gotten even one through?
I've gotten a lot through. I have a volume practice.
That's actually unusual, because in Florida we're not getting them through.
I had a client 2 days ago who got a $400,000 principal reduction.
Terrific.
And essentially
what was the principal amount?
What?
What was the principal amount?
The original principal amount was about $600,000. But even Bank of America, who holds a huge percentage of these, they said they sent out. It's basically winning the lottery. They sent out 200,000 letters, but they hold millions of loans.
Do you know who they sent them to?
I'm not exactly sure. It's
usually the people with the 800 plus credit scores.
Oh, okay.
Why?
Yeah.
Because they want to keep them as clients.
I know, but
right?
look, and the simple fact is, GSEs don't qualify.
Right.
So and if you look how the money was distributed, California got a huge percentage, certain states got huge percentages, so at the end of the day, it's really not going to help. I have a lot of clients who come to me all the time saying, am I going to get this? And I tell them, sorry, no.
The clients that we have that have gotten any letters are only the clients that have the really high credit scores. They had no problem to begin with, but they're suddenly suddenly they get a letter that says your interest rate has now gone from 5 to 3, something like that. And they're surprised and delighted, and they never missed a payment. It's the people that are struggling.
No, all my clients are behind. 100% of them are behind.
100% of them.
100% of my
In
clients. All my
Florida,
clients.
it's the ones that are
Yeah.
getting the 800 credit scores.
Every
that
single
are-
one of my clients are all
Yeah.
of my clients are seeking loan modifications or some other type of relief to
Right.
get themselves current. So, like I said, it's like winning the lottery.
You never
you have
know.
no rhyme or reason.
Yeah, for us, what we see is just the ones that are on time. And it's like, well, they certainly want to keep them as good customers. So I don't know if this settlement is really, you go to nationalmortgagesettlement.com, that's where you'll find everything. Each bank, there are five banks included, Ally GMAC, Bank of America, Citi, JP Morgan Chase, and Wells Fargo are included. Each bank has about a 500 to 1,000. Now, a lot of these are like signature pages, so don't be too. You can download all the PDFs of each one. In many of the PDFs, the signature pages, like 50 states, each attorney general signed it as a different page. So don't be too disarmed or alarmed when you see how large they are. But for the most part, this isn't. They've got 3 years to do this, and the question is, why do they do this? Well, remember that within this system that we're going to talk about, that they were not reporting when every transfer was supposed to take place, right? So, and it's talking about the fraud, it's talking about the problems with being able to foreclose them, or the fact that there were foreclosures that took place that probably shouldn't have taken place because they didn't have the correct documentation. And there are even some states, like Wisconsin, who has said, yeah, we got the settlement, but we're not going to give the money out. We're going to give it to our budget shortfall. I don't know who this attorney general represents, but he certainly doesn't represent the people. He's putting all the money into the budget shortfall and not to the people that actually need it. So I think it's important for you to know about the settlement.
Yeah, one other thing that I was told by an executive of Bank of America, the way that they're doing this, and it's obviously how it shouldn't be, is if you don't qualify for HAMP or HAMP Tier 2, if you don't qualify ordinarily for an
You mean
in-house, no, I'm talking about HAMP, for a
okay.
modification. So if you don't qualify for a regular, MHA modification, if you don't
Right.
qualify for an ordinary in-house modification, they're putting you into the calculation for this. And like I said, if you're lucky, you get it, but if you don't get it, you're out of luck.
Right.
That's how they're working it. So like I said, they're putting people who are far behind into it, and if they're lucky and they win the lottery, they're going to wake up one morning and they're going to have a $100,000 principal reduction.
Are you in the state of New York?
Yes.
Okay, so like I said, in Florida, what we're seeing for our clients is that it's not the people that are behind that are getting it. So I don't.
It might be arbitrary the way
And I don't know if we're doing it state by state, and each person, like Bank of America may have, and frankly, the loans that I know about are Bank of America because they seem to be the most active with this.
Right. Because I think they're essentially, they have all those old Countrywide loans, and if it's Bank of America owned, serviced by Bank of America, those are really the ones that they're pushing through.
Right.
So that they're the most active, I think.
Because of the repurchase agreements.
Correct.
Remember, there are repurchase agreements that are going to protect them. Yes, ma'am.
Another area is, with the traditional loan mods, they require so much documentation to be provided by the homeowner. With this one, they just ask you to sign a 4506.
Yeah.
And that's it. And give a proper.
Well, think about the loan mods. How many times did you submit documentation as a loan mod? How many times did they lose the documentation? Did that happen?
Yeah.
Do you know why that
I have a
happened?
staff of 15 who basically that's all they do is submit.
Do you know why that happened, though?
No.
Every time they got $1,000. Do you think a loan servicer, a special loan servicer who won, gets more money as a special loan servicer? Anything that's in default becomes a special loan servicer, right? Because supposedly it takes more time to go after and to service the loans that are in default. So every time they got loan documentation for modification, they got another $1,000 under these statutes
From the government?
from the government.
You gotta be kidding.
No, not kidding. Not kidding. So why do you think this is happening? We've seen some people do it 7, 8 times. Yeah.
All the time. They don't have
Because they're always like, oh, your documentation is lost and now we got to start over, right? They got another $1,000 when they start over. It's amazing. I don't understand why this is being allowed to happen, but that's what's happening.
You know, one thing I bring up is that it's what I call the chicken and the egg issue.
Mm-hmm.
You can't modify the loan without the approval of the note holder.
Right.
The note is in a pooling and
Yes.
service, in a pool, and it's governed by the pooling and servicing agreements.
Which doesn't
Many
allow
of these
it.
don't allow you to modify.
Right.
The banks are out there still trying to do modifications.
Right.
So, I mean, the question is, do you really have a modification?
Yeah.
If you to work something out with a servicer, the note holder can turn around and say, I didn't agree to that, I want my money.
I think the question is, who's really committing the fraud?
That's right.
Who has the authority? It all goes back to authority.
First, the chicken and the egg.
Authority and standing. Authority and standing.
Go back and
Keep,
say, I don't know.
yeah. But we keep thinking of this. Authority, who has authority? That's huge because that's where the robo-signing comes in. And then if they have the authority, do they have the standing? Do they actually own the note? Do they actually get the mortgage? So those two issues are going to come up repeatedly. Do they have authority to do the modification?
Right. The problem is, everybody's going into these ham conferences.
Right.
And my question is, why would I even be talking to you if you don't prove to me that you have the right to modify this and you own the mortgage?
And that's what makes
And
me
then
angry.
all
They
these
ask my
systems
clients,
now.
they ask my clients for reams of paper, right?
Yeah.
Yeah, fill this out, do this, do this, do this. And what have you done to figure out if they actually have a right to be at the table? Do they have a right to be at the table? That's the question I have to ask is, do you have a right to be there?
Yeah, and the problem is in New York, as soon as they file an order for a judgment foreclosure, it is automatically stayed and sent to the settlement part. And you're in settlement, and if you don't reach the settlement, then it goes back to the IS judge, and they can go ahead with the foreclosure. The question is, you don't even get to litigate the issue of standing until after you decide whether you're going to modify or you say, no, we'll just go ahead and litigate.
But it happens, it goes to the settlement conference before they get the judgment of foreclosure. Once the
Yes.
summons and complaint is filed, then a couple of days it's sent there. But what you can do is once you get the copy of the summons and complaint, just go ahead and make a motion.
Yeah,
And it'll
don't
take
you,
it
motion for
directly out.
discovery?
Not even a motion to dismiss.
Motion to
Yeah,
dismiss.
I mean, that's what we're
Based on that,
recommending,
okay.
motion to dismiss immediately on all these cases.
All the cases, okay. We do discovery immediately. We always, because once there's discovery pending, then they can't move forward. So that's what we do, because nothing can move forward until we get the discovery. And I don't like the settlement conference because most of them that we deal with, and I'm sure it's a little different here, when we deal with the settlement conference, it's almost always in the context of loan modification. Not, do you have a right to be here?
Exactly. They don't even,
Right. So they don't even address that issue. They just assume that they are right. So, okay, this mortgage securitization, the public record issues, the mortgage usually is posed in the name to MERS, right, as nominee mortgagee. It'll say the lender, but then it'll say that MERS is named as nominee or mortgagee. And the assignment of mortgage usually occurs only after a default. And we'll see why the problems with it being after a default. How many of you have seen the assignments after the default? Huge, huge issue. And that's when it comes into the REMIC status. That's when it comes into Securities and Exchange Commission status. The note is usually closed in the name of a lender, not MERS. So it's interesting that we've got the mortgagee as MERS, but the note holder is usually the lender who then endorses it over. We'll see what it's supposed to be and what it normally happens. It's two different things. Always two different things. I've not seen not one, done the way it was supposed to be under securitization. And there is an issue of the separation of note and mortgage. How many of you are auditors here who do securitization audits? Okay? I know that this becomes a big issue, that they like to talk about the Carpenter case, right? Carpenter versus Logan, which is a 1847 case, about the separation of note and mortgage. That is not the strongest argument, though. So you need to kind of back away from that argument and look at some of the other arguments that we're going to talk about. But separation of note and mortgage, most of the courts, and I think even here, that might be the case.
Right, that if you separate the mortgage and the note, then you don't have enforceable mortgage. And virtually all of them are subject.
Because they have cited Carpenter, almost all of them. I've never seen one that isn't different. When you look at the mortgage and you look at the note, and they've gone two different paths, right?
They always do.
So it's actually New York is good then, because in Florida they say they got the note, they win. And which it's like there's no chain of title requirement. We're fighting that. I'm not sure where that's going to go because like I said, the case law in Florida isn't as developed as it is in New York, which is great.
In New Jersey, it's practically going in the same direction. They are arguing that you got the note and the mortgage following it. Therefore, it's not important so much at all for the foreclosure purpose to have a mortgage signed.
So he's saying that in New Jersey, I'm just doing this for the video, he's saying in New Jersey, as long as they have the note, that the mortgage would automatically follow.
The tendency right now by every judge will have been from the sum section.
Yeah.
Just to go the dictum of the, and I quote it because although it's a lot of confusion with respect to the concept of the mortgage following. Does it mean that they have to be united? Or does it mean that while they are separate doesn't matter? Because in effect, as long as there is a note in the hand of someone and a mortgage somewhere, then they can go ahead and foreclose based on UCC concept.
Right.
Of the whole.
But that's a problem though, when you've got the note going one way, and they're saying as long as it ends up together in the court, that it's good. And the question is, doesn't it get severed while it's out here? You know, when it's been separated.
The tendency in New Jersey right now is a concentration on who holds the notes.
Right.
The majority of the cases that have been, they have been dismissed for standing because they cannot prove the transfer of the note prior to the filing.
Exactly.
And
for me, that in Florida it's the same case, and he was saying that one of the reasons that so many are dismissed is because they don't own the note when the day they file, and that is fairly universal in most states. That if you don't own the note on the day it is filed, then you cannot pursue the foreclosure. The problem is that most endorsements do not have a date. And this is addressed, there's a New York case that addresses it and actually dismisses based on the fact that there were too many issues and because they couldn't show that it was endorsed on a certain date because of a bank going out of business and et cetera, the court said that they didn't establish their case and they dismissed it. So Oliver will be talking about that. That date of transfer of the note can be extremely important. And in almost no case is it documented.
But I believe also that the PSA has a provision that it has to be reception, has to be certified.
I understand that, and we'll be talking about that. So does the REMIC. Securities and Exchange Commission requires it. IRS requires it within a 3-month period in most cases. But you don't see that. And with an endorsement in blank, notes are typically not, if they're a negotiable instrument under UCC 3, they're not typically dated. Now, if they're a security instrument under UCC 9, and we're talking about this too as well, then they should be dated. Have you ever seen an endorsement dated? Anyone?
No.
A date on an endorsement of a note?
But what they are doing is using the rule of evidence by creating computer documentation that is supposed to be evidence of the...
Yeah, but that's not certified. The question is, can they certify to that? Can they do an affirmation on that? So, let me go back to the slides here. When we were talking about MERS, almost every mortgage then is, this is just a copy of a mortgage. You know, I did a screenshot of a mortgage. And of course it says MERS is a separate corporation as nominee for lender and lender successors and assigns. So the operative word is nominee, right? What's a nominee?
I'll be discussing that.
I put a definition in here, but it's a person or entity who has requested or named to act for another. Okay, if you don't exist anymore, can you still act for another? Can MERS transfer paper if the lender who has named MERS as the nominee Can MERS do that? There's a great case in New York about that. And it says a potential successor to another's rights under a contract. So a nominee is a potential successor. Is it the successor? No, it's a potential successor. So look at the definition of nominee for MERS. These are all little arguments that you've got to be able to bring up to the court. And I also wanted to show what the note, I'm assuming that most of you have seen the notes. The notes normally paid to the lender. So this was the same transaction. If we saw before, this was Mortgage Lenders Network USA as the lender. And here, the notes payable to Mortgage Lenders Network USA. This is one of my clients that said, allowed me to show his paperwork because it was such great paperwork with the title and everything else. To transfer a note, it is endorsed, I-N-D-O-R-S-E-D, endorsed under UCC 3 or UCC 9, or an homage is attached, okay? Usually there's no date, but the date can be important, as we were just stating. The date can be very important on these transfers, but I've never seen homages I have seen with dates, but endorsements, usually with that stamp. And by the way, there's a lot of robo-signing on those stamps, so always check your signatures. Every single signature you've got to check. Check the notary signatures, check the any assignment of mortgage signatures, check every single signature, and then if you just Google it, in almost every case you will find that person has signed for many, many different banks. And that goes back to the authority issue. Authority and standing. Those two are the main words for today, authority and standing. If they're robo-signers endorsing, they have no authority. You can't transfer something unless you actually work for the company. What are you going to ask for if you're defending this action? You're going to say, give me the employee records of that person showing that they work for that company, right? Payroll records.
I saw a note this week, and the bank's attorney sent it over and said, oh, we've got the original note, and I'm certifying this. And sure enough, there's the stamp from the original lender, and there's a signature line there. It's not dated, and there's a signature there. It's unnotarized. I don't know who this person is.
Notes are never notarized, though.
Yeah, but how do you prove that that is an authorized representative of the bank? But a lot of these banks are now out of business. And it's going to be, they're going to have to rely pretty much on hearsay, because where are they getting a live witness to say, that's the search person's signature?
Usually there's a successor or a sign, though, in the bank. FDIC, someone has those records. Ask for the employment records. Ask for the employment records of that person. And as I said, Google it. And I have found, I have a case in Indiana where somebody had robo-signed for 5 different companies. 5 different companies. And it's like, who had authority there to do anything? I mean, she probably worked for the law firm. In Florida, it's the David Stern firm that we always talk about, because they're out of business now. They had paralegals, attorneys within that firm signing on behalf of MERS. There's no authority there. If you have no authority, there's no apparent authority, no actual authority, then that is an invalid transfer. So attack the authority, attack the standing. Yes, sir.
And I don't know if Oliver's going to touch on this. Several of the assignments on cases that I'm actually dealing with, the assignment was signed on behalf of MERS as nominee by someone who worked at the plaintiff's law firm.
Oh, that happened, yeah.
Romano,
All the time.
Bacchus. And that's for New York, that's an ethical violation for the attorney. You
I don't know
on both sides
about
of
New
the
York,
coast.
but Florida is extremely slow. And I keep talking about Florida because Florida is where we have most of our cases. Indiana, because it just wasn't as upside down as Florida. Florida, 1 year we had 22% growth in the value of the homes. That was where the bubble really took off.
And
So-
again, I don't know if Oliver's going to touch base on this. How I've been successful in getting foreclosures thrown out has been on the actual physical delivery. They can't produce anybody who can actually attest that they saw or they have personal knowledge as to physical delivery of them, because a lot of them.
And that's where your New York case law is terrific. Honestly, that's where the New York case law versus the other jurisdictions like Florida, maybe New Jersey, where in Florida you show up with a note, and frankly, I've been in courts where the notes are both in bankruptcy court. The original note, which is signed one time, is both in bankruptcy court and trial court. How is that possible?
New Jersey Central delivery and transfer, especially when you have a better endorsement. Because if you cannot prove that you transfer the note, gain possession of the note prior to the filing, then you have a problem. The problem, as I said, is that banks are very, very imaginative in their creation. And I call it.
Right.
What they are doing now is that they are creating computer documents, which they now are trying to have
To match up with the note.
by on the
Right.
hearsay section of business documents, and then they get it in. And then we have someone that will come and say, oh yes, I use it in the computer, and I always saw this. And it usually has the date of the closing of the PSA and the date of the transfer.
How convenient. How convenient. And almost always that's the PSA, that's,
Well, the problem is...
It doesn't happen.
I know you want to talk to you. How we can get, in fact, there is in the PSA that this transfer from the seller to the depository, from the depository to the trust,
Right.
has to be certified by the person that received it. And interestingly enough, there is an article that was written by one of the bank attorneys, which saying that, oh, no, these are kosher transactions. I've been for years doing securitization. And then in the slip of the tongue, he said, every transaction usually is not only backed up by the PSA, but by a separate agreement by which the seller transferred into the depository, and the depository also too. That is
There's a separate agreement.
There is a separate agreement too.
I'd like to see where that was mentioned, because that
Yeah,
might be, during break, maybe we can talk about that.
No, I don't have the copy with me, but I will
Okay.
send it to you if you give me it to others.
Of course.
if they want.
My email, if anyone wants it, is attorney@suethebanker.com.
Have you seen any of these cases where the the mortgage is actually, the note is actually transferred to the custodian to the sponsor, and then the sponsor to the trustee?
Never.
As it's required to be in the
No.
pooling and servicing agreement? I've never seen it happen.
Not one.
And nobody's ever tested this in
And
New York.
not only do we have cases in litigation, but we do, we've seen a lot more than that.
Have you ever seen any of
Never.
them bringing the
Never saw
custodian to testify? Never.
But I don't know, I think, a homeowner, mortgagor would be a third-party beneficiary to the pooling and servicing agreement, and they could argue it.
In most cases, they're saying that there is no standing for the
Yeah, they're saying
homeowner
there is
to
no
even
fee, but there is
attack
no-
that. Almost every case out there, particularly there's California cases that say that there's no standing for a homeowner as a third-party beneficiary to even attack it. It's got to be the investor coming back in saying that there was a that they have a right to be there.
Right, how do you deal, that was my next thing.
Right.
A lot of, because one argument of mine was rejected, that they had no standing because the PSA and that part of the contract was between an investor and, so how do you deal with it?
It is a problem in Florida. We even have a case that a half-a-page opinion on a pro se appellate court case that said it didn't matter if the note and if the trustee held it or not. It didn't matter. In other words, it didn't matter who owned the note or who owns the note. It's a horrible decision, and we want to go in to make sure that that's appealed. We want to get, in Florida it's a little different because they have a lot of different appellate divisions. And so we're trying to get a contrary ruling so that it'll go to the Supreme Court in Florida. But it's a problem.
It definitely is. Right now, the way I'm trying to combat it is where during discovery, I asked for the custodian of a trust to produce the acceptance receipts.
Right.
And I'm arguing
Max
it's not.
Gardner's really big on that.
Right. I'm not stating that, I'm not arguing that they have a right as a third-party beneficiary to bring it. It all leads
Just
to the
show
question
it.
of standing.
Right.
Okay, we're not talking about whether my client has a right to to argue that. It's
Right.
whether or not if you can actually be at the table.
But the question is, the Privity Act is based on the majority of these cases in which the trust is under New York law. It's based on general law that they look at, including one of the negative decisions of New York in which they deny the argument of the standing based on, I don't recall the case right now, based on the fact that black agreement. Only an Alabama case I found in which they found that there was freedom. However, I believe that that is the common approach. We should approach it from the EPTL point of view.
The what?
The EPTL
Okay.
point of view. It is the reception of the property of the trust which makes the trust, and in the state of New York, it is irrevocable and has to be there complete. If not, the trust is not the owner of the property.
Correct.
And
Correct.
therefore-
You can't, if you don't transfer it to the trust according to the trust rules, which usually are the trust rules are New York law, and it's very specifically, you have to go by that law.
Or in New York, you cannot have a string attached. You cannot say that
It's
now
here,
I'm going
but-
to, it has to go completely to the trust.
Right.
And if not, the trust is not the owner of it. That is, the privity argument should not be even used because it's a very strong argument in favor of the banks. Okay, so what? Okay, they violated all of this. The one that has the right to sue is the investor and the other members of the PSA. But it's different if in reality the trust itself doesn't own the law
Right. Right.
because they violated EPTL.
Standing. We go back to the
Well,
standing.
they are not the party interest because they are not the owner of the law.
Let's go on. To transfer a mortgage, what do you have to have? You have to have an assignment of mortgage. Those are always in writing. Those are always filed. And if you match that up with the note, does it ever match? Never. I've never. Have you seen? No.
Some of them are done by written assignments filed, some of them are done through the MERS system itself.
I see MERS filing, but then this is why the quiet title. Why we bring quiet title up later? Why I'm going to talk about it is because these assignment of mortgages are never filed. So who do we go after? Who's on title? Who's on title?
The old bank.
In the land record?
The old bank that's out of business.
But you see,
So-
the problem is that in a jurisdiction like New Jersey, and even in bankruptcy federal court, they will tell you, okay, it's important for the priority of the people who are trying to compete, let's say, about who takes first. But the important thing is there an assignment that was executed by a particular date?
Assignments
And
are
not that
dated.
It is important in New York, because
Yeah.
in New York, in order for you to foreclose, you have to file the assignment.
Right.
So,
Well, and they're dated. That's the good thing about assignments, because they do, and they're usually notarized.
but there are a lot of jurisdictions in which you don't have, in order to have the right to foreclose, you don't need to have the assignment report, as long as the assignment was prior to
Correct.
the.
Which they tend to file, and we sometimes see post-dated. We think they're post-dated, but we don't know. Separation of note and mortgage. I'm going to try to keep this going, if you don't mind. Separation of note and mortgage, the Carpenter-Logan case. And I know a lot of you are citing this as the end-all. In New York, it actually has been cited many times. But my concern is that they cite it, and then they don't use it. Is that, am I right about that? Because I read the cases here, and they cite it saying you can't separate the note and mortgage, and then they talk about the fact that the note's gone here, and the mortgage has gone here, but we're still going to allow it to happen?
Well,
No,
In New
wait,
York,
wait.
It's a coupling of both the separation of the mortgage and the note and the issue of the chain of title and assignments.
Mhm.
Because of MERS being the only named mortgagee.
Right. And to me, there's a separation almost immediately. As I said, if we've got the mortgage going immediately into MERS, but the note not going immediately into MERS.
Yeah, it usually
So
within
almost
24
immediately,
hours, they're all
at the
separate.
closing table.
Yes.
They are totally separated at the closing table.
But that argument, I believe in New York, that argument's been rejected because
Right.
it was consensual separation as opposed to an unconsensual separation.
Which,
That's why I'm wondering how is it being brought up? Because it's been knocked down in New York. I don't know.
I'll go through Silverberg
Yeah.
and all.
Oh, you're gonna go, you're
yeah,
gonna
he's
go.
going to talk about Silverberg,
That's
which is
exactly
the
the case I was
primary
talking-
case.
yeah.
So we're going to talk about securitization. I know some of you are still looking for basics, so you'll have to excuse me if I go into more basics still. And the securitization of pool of assets having an income flow, all of which belong to a special purpose entity created for the sole purpose of owning the assets. Investors buy the shares in the pool, which are categorized into tranches. They're designed to be bankruptcy remote, so claims from the originator or participants do not attach. Special purpose entity is taxed as a REMIC, real estate mortgage investment conduits, as pass-through entities. And we're going to talk about all of these. And the reason why this is where you can bring up arguments. Obviously, everything that we're talking about is where do you bring up the argument. They're often wrapped with insurance to enhance the credit worthiness, and there are private securitizations, and then there are Freddie Mac, Fannie Mae, and Ginnie Mae, I should have put, securitizations. And I know you can't see this, I'm so sorry. The securitizations start though, and if you look, this is where the tranches are. Where these were rated AAA up here, AA, B, I think this was triple B or C. Now let's talk about why those were rated that way. Because initially when I heard that Moody's had rated subprime mortgages as AAA securities, I had a problem with that. Did anyone else? Right? Besides what we thought was collusion, which I don't know if they fixed that issue or not. They do obviously have a lot more regulations in place now. But in dealing with mortgages, this is what I know, is that I love to buy partial mortgages. And the question is, why do I love to buy partial mortgages? Because I can buy a partial mortgage, and let's say a note that had, and this is my explanation for it. Let's say a note that is a face rate of 8% over 30 years, and I buy the first fourth of that 8% mortgage. Do you know what my yield is on that first 8? The first, if I buy 1/4 of a mortgage at 8%, my yield is 32%. And that's because the time value of money, and now that's not an exact figure, it's like 31 point something, something, something. But it's in your mind, it's easy to figure out. I take the denominator, the 1/4 times the face rate, and that's how I know what my yield, approximately what my yield is going to be on a mortgage. So if someone comes to me and I say, maybe they've held a seller finance note and they say, I got to pay for my daughter's wedding, I need some cash, and they've got a $100,000 mortgage, and I say, well, I'll loan you $25,000 on that. let me just have the next fourth of those payments. It's an 8% note. I'll make 32% yield on that. Anywhere else can you make 32% yield on a first mortgage on that kind of security? So if I foreclose, do you think I'll be covered in most cases? Right, if they don't pay me back, do you think I can foreclose and get not only my money, because of course I'm going to get attorney's fees and costs. So that's a really great investment, right? Yes, sir.
How do you buy the mortgage? I'm trying to figure out how you're doing it. If a bank's holding it or some other entity's holding it.
I'm talking about an owner financed mortgage in most cases, but I'm using this as an example as why the tranches then, where the banks were holding it, could rate something AAA. Okay?
Tranches were done for investment purposes.
Right.
Classified.
So this is like saying, this almost looks like a 50%.
Right.
So if I bought half the mortgage, and the mortgage was at 8%, and I bought half, their yield, because they're going to get paid first, and their risk, because they're going to get paid first, is 16%.
It's always private loans.
In most cases, I bought from banks. I know how to buy from banks, but in most cases, you're going to be buying owner finance. I bought directly from MERS as well, because I've been in the business for 6 or 7 years doing this. I mean, before this was all a big fiasco, I was buying and selling mortgages.
Have you bought from the trust?
No, I have not bought from trusts. So it's kind of odd that I'm on both sides, but I have, you may have missed it, but when I said I buy and sell mortgages, the last one that I just filed a foreclosure on, because I buy the mortgage, I know that this person has already gone through bankruptcy, thank God, because MERS transferred it 3 times. There's issues, but there's no one there on the other side to contest it, because the owner or the payor of the mortgage has already wiped it out in bankruptcy.
But have you ever tried to buy it through a trust with the credit swaps reducing the value?
No, they're not going to do that. In most cases, they're not going to do it. They've already put it into another special servicing situation where you can buy it directly from MERS or you can buy it directly from FDIC. But the whole point is that they could rate these tranches AAA because you've got loan to value. You know, if you're in the first 50%, you've got loan to value of 50%, right? Do you think value's going to go down 50%? Probably not. We went down almost that much in Florida, but not quite. So they could rate this AAA, even though it was subprime. So even though it didn't have the best credit, if anyone came to me and said, I need money on this mortgage that I'm receiving payments for, and they just want a portion of it, I do that in a heartbeat. Because I know, particularly if, say they want 1/5 of it. So we've got a 6% note, and they want to sell me 1/5 of their mortgage. What's my yield? Huh? 30. Can you make 30% on any secured? No, you can't make it anywhere else. That's why I love mortgages. That's why I dance when it comes to mortgages and investment in mortgages. I'm sorry?
You only do it in Florida.
No, I do it anywhere. Yeah, do it anywhere that makes sense. I have to know that the value, current market value, I have to know that the current market value is there. And in most cases, I'm only going to do, I'm buying mortgages in Florida. I paid $12,000 for a $176,000 mortgage. And I can sell that house for $80,000. I'm way under the market. Yeah, it's kind of, and my firm can do it. And I can represent myself, and I know what I'm doing. So, yes. Oh, yeah. 29 years. So, yeah. Yeah. So mortgages, if any of you are interested in knowing more about mortgages, ask me. I'll be glad to talk about them because that's attorney at suethebanker.com. Attorney at suethebanker.com. Yeah, National Note Association is my other business. That's where I buy and sell mortgages. That's where I teach people about mortgages too. But honestly, right now, there's not a lot. I would buy and I would flip to institutional investors. I could do that all day long and make 3 to 5 points, meaning 3 to 5% on everything I flipped. Almost all the institutional investors are gone now. So you almost have to have a private fund or your own money to do that. So it's a lot different. I'm sure all those funds will come back because it's a good thing, particularly the partials, if you love the partials. But like I said, the reason I'm telling you this, and it's easy to understand then, is that if you've got low loan to value, that you can get in it for 50% of your loan to value. If they don't pay you back, you foreclose and you're still protected. And during that time, you're making, because of the time value of money and the fact that it's been amortized usually over the 30 years, and you're getting it within a shorter time period, that's where you get the high yield. Now discount that. That's not even discounted, that's par. Remember, par is when you pay exactly what it's worth, basically. If you had a $100,000 mortgage and I gave you $25,000 for the next fourth of all the payments coming in, a fourth of all the payments coming in, that's par. In most cases, I can say, that's an easy one to do with par, but what if I even discounted that more? Higher yield, if I can discount it more. So, if you like a secured investment, there's no other place to put your money. For me, I mean that's, and you can do this through retirement vehicles. You know, a self-directed IRA. So it's all goes tax-free. So it's a good thing. But that's how they could rate. You know, I want to go back. This is how they could rate the subprime with a AAA rating. That's important to know. Requirements of the trust. Most trusts are under New York law. There are some under Delaware. Most that I see are under New York law, right? Securitizations that are taking place. Most are established via a pooling and servicing agreement. Where do you find the pooling and servicing agreements? Anyone?
Edgar Weiser.
Edgar. Yeah, what's Edgar? It's the research tool that the government has. If you go to Securities and Exchange Commission, you can usually find those. Frankly, because we're not so many years into it, if you Google the name of the trust, if you happen to know the trust, in many cases you might because of, if they've already been foreclosed on and maybe foreclosed upon, you know, New York Bank as trustee for XYZ Trust, you can usually Google that and find the pooling and servicing agreement because a lot of attorneys have shared that. If you put it on Scribe or Real Docs, or I'm trying to think of some of the other services that we've used in order to find.
It's on the face of the sun.
I'm sorry?
It's on the face of the sun.
Yeah, right. But to find the actual document is what we're talking about, because obviously we practice in New York, right? We've got New Jersey. Where else do we have? Anywhere else besides New York, New Jersey?
Virginia.
Virginia?
And California as well.
And California? So it's trying to keep up with everything. California is very different with quiet title. And by the way, if you practice in California, let me know, because I get tons of calls to represent people in California because of the website, the Sue the Banker website. And I understand that in California, you actually have to put up bond to do a quiet title
There's a
action.
tender rule, but if you're just attacking the deed of trust, you can get around it.
Okay. I don't know, and I just say we can't represent, so give me your card, because I can probably do a lot of referrals if you're actually working out there. But I'm glad that everyone's here and that you're sharing, because none of us are going to be experts, because this law is changing so rapidly. So there might be a couple of weeks where I'm involved in court and I'm doing whatever I need to do just to keep up with the practice. And there may be cases like the Massachusetts case that some of us talked about as we came in. The Massachusetts case was just last week, and it's confusing. Has anyone read the Massachusetts case? It was, where do we put it over here? Eaton, E-A-T-O-N versus Fannie Mae. And it talks about whether you needed to own the note and the mortgage at the same time. And they talk about in Massachusetts that it's a different, let me read something on it, because it's totally, Massachusetts is considered a mortgage state versus a deed of trust state, right? And yet they say here, and this is what confused me on it, that that in contrast, this is on page, on the 5th page, okay? It says, in contrast to some jurisdictions of Massachusetts, the mere transfer of a mortgage note does not carry with it the mortgage. And it gives a case side. The prevailing doctrine upon the subject is undoubtedly that an assignment of the debt carries the mortgage with it. This rule, however, is by no means universal and is subject to various qualifications in the different states of the Union.
That is because Massachusetts is a mortgage title jurisdiction, in which the mortgage transfer.
Right, can I talk though, please? As a consequence in Massachusetts, a mortgage and the underlying note can be split. But they talk about the fact that it is much different than a mortgage state versus a deed of trust state. Thank you. Because as he was saying, it's the title, but they actually consider that as a mortgage holder, you take title. Very different. So this is a very difficult case to use anywhere else. In some places, it says that you need to have both the note and the mortgage.
Sounds like New York.
Silver. Okay, good. But in other cases, it says it's okay if it's just the nominee that has the mortgage. So I think it's confusing case law. Let's get back to REMIC, though. And do continue to participate, though. I appreciate that. REMIC is the tax status that the securitizations are given as pass-through mortgage entities. And at the close, it specifically states that as of the close of the 3rd month beginning after the startup date and at all times thereafter, substantially all the assets of which consist of qualified mortgages and permitted investments have been moved over to this qualified entity, okay? 3 months. How many assignment of mortgages take place years later? Years. Years and years. Usually 4 or 5 years. They usually don't take place until there's a default, right? I mean, that's what we see. In fact, I keep telling clients, don't come to me. They'll call and they're not quite ready to, make that commitment, pay that retainer or whatever. And I keep saying, if you're going to default, be careful, because as soon as you default, within usually 30, 90 days, they'll start moving those trusts over. And so the quiet title actions become more difficult because they may have started their paperwork in that time. Obviously, you use this as a foreclosure defense technique, and that's where the securitization audits, where we'll talk about that. But for the purposes of quiet title, it's pretty tough once the assignment of mortgages have become of record and become part of the title. That's pretty hard to do those quiet title actions. So you try to get those quiet title actions in before they get in default. It's also the question of you don't want to go in front of a judge and the judge say, well, are you paying your mortgage? And they say, well, I haven't paid it in a couple of years. Well, you don't deserve, it's an equitable action, right? Do you have clean hands if you're not paying your mortgage? I keep telling people, please try to continue to pay your mortgage, and then once we start the action, you may need to pay it into the court. So,
But I understand, you're absolutely right. It does make it a lot more difficult after the
Yes.
assignment has occurred.
right.
But my question to you is, it all goes back to the issue of standing, because isn't an quiet title to make a determination as to who owns it and give notice to whoever does own it to step up to claim their money?
Right, but I don't want that notice to be public record. I don't want that to be a public record that I needed to give them notice, right? I'm hoping across the board I get defaults on these.
But 9 out of 10 times, if you're doing it as a counterclaim,
Well, I don't like counterclaims. You know why? I don't like counterclaims of a quiet title because that keeps you in foreclosure court. And usually foreclosure court or the foreclosure mills, I mean, it's the same judge hearing the same argument, and they're saying, did you pay or didn't you pay? Well, if you didn't pay, foreclose.
so are you bringing it after you get the foreclosure?
We're bringing
knocked
it
out?
in a different civil court. We're not bringing it at, it's, quiet title is very different than a foreclosure.
But
It's a declaratory judgment in a civil action. So we're taking it out of the foreclosure courts. And I don't know how it works up here, but in Florida, you have 2 or 3 judges specifically assigned to all the foreclosure courts. I do not want a counterclaim in those courts because those judges do not take the time or effort to read what the law is.
But aren't you afraid that the foreclosure attorney is going to file a motion to merge?
That's okay, but I'm going to argue that it merges back over to the other.
Oh, okay.
Okay, I want it back over here to the judge that isn't swamped with foreclosures. Because
Which foreclosure court are you going to? Are you moving into a federal court?
no.
This is Florida.
This is still, I'm in Florida, I'm talking about Florida. There may be 2 or 3 courts that only handle foreclosures in Florida, because there's
Just like that here,
so
too.
many, so many. And is it the same here in New York?
No. It's very consistent with judges who handle foreclosure.
Oh, right, fairly consistent,
They're the
right?
same team guys.
So don't you want that out of their courtroom?
Absolutely.
You want a quiet title out of their courtroom.
Right.
So you bring it separately. And if they move to, if
How
they
do you do
move,
that in New York?
You get
It's
the same
not-
judges, you get Adams, you get them all the same. I know which judges you
yeah, wait, I don't know if you can even, in most cases, it's a lottery, isn't it, for judges?
Yes,
It's ISS.
Right, so it's randomly assigned. Now, except foreclosures for some reason are,
Well, there's a settlement part, they all go to the settlement part upon filing a request for a judgment. And the whole action stayed and then goes to that one judge at the settlement
get.
part.
Yes, so you're back to where you said. You want to get away from that judge.
you want to get away from the foreclosure judges.
See, it's random in New York because there's some good judges and
Okay.
there's some bad judges.
And in a lot of courts, it's not random, and in Florida, it's definitely not random. And I don't know if you know this, and in Florida, most of the filing fees are $1,000, $1,900 for a foreclosure. It's based on the value of the property or the note.
I'm a little bit confused. I'm sorry.
Yeah.
You're saying that a quiet title action, it doesn't belong to the Supreme Court, state courts?
No, it belongs in state
Yes.
court, but it belongs as a separate action because it's declaratory, it's a request for a declaratory judgment. It is not a foreclosure. So if you have courts that say we handle foreclosures and therefore it should be there, I argue against that and I would like to keep it a separate action. I want to keep it out of, it's almost like it's become a mill. You know, that the court has become a mill. They do so many of them that when you bring up an extraordinary argument like a quiet title, they knock it down. They don't even pay attention to it.
I would think that in New York, basically, the
Yeah.
movie's going to have a choice to bring it to whoever. It's just going to be placed in front of the clerk, maybe you can probably distinguish it as your full court.
And they may seek to join, but see if you can get it to join as with the quiet title being the primary action. That's why I like to start quiet title before the foreclosure starts.
I have a problem at New York because number one, in foreclosures, the bank has the burden of proof to prove its own standing. Even if you don't even have to put in a affirmative defense. As part of their own case now, they have to show that you have the ownership. Number two, you don't have that. You have the burden of proof in the quiet title action.
Right.
So if you bring that first and you lose, then you're stuck in the foreclosure. So I find that it might be better to use it as a counterclaim.
Okay.
And number one, you can.
Do counterclaims cost you anything here?
No.
If I counterclaim in a foreclosure in Florida, it will cost me that same $1,900. Do you think my clients can afford it? They can't. So that's the other thing. That's the other reason why we have to bring it separate. I can afford. They can afford the $400 filing fee, but the $1,900 filing fee, in most cases, they can't afford it. So it also becomes economical.
But then you're taking, like you said, the burden of proof out of the bank's hand, and you're now taking the onus of it.
Right, but if I've got title, and I've only based my quiet title on who's on title, and this is before default, so they haven't done all the, the backdating and assignments and mortgages that take place. They haven't done all that. I only have to notice who's on title, because I don't think they have a continuing right to have what they have. And most of them don't even have service available. I mean, literally, I'm serving Secretary of State in most cases because there's no one to serve. You actually are hoping for a default in most quiet title actions because you don't want to have all these existing companies. You want to have who's on title that don't exist anymore. And if they didn't file their assignment of mortgages, whose fault is that? Whose problem is that? It's their problem. Do I have a quiet title? Sure. I mean, we'll get into that more though. But let's look at the REMIC tax status. So at the close of the third month, that's the same thing that you'll find in the pooling and servicing agreement that we're going to talk about in a few minutes too. Close of the third month. In most cases, you can't transfer a defaulted mortgage into a trust. You can't, the pooling and servicing agreement says no. So this is, REMIC, remember the 26 U.S.C. 860D, that's IRS. That's the IRS code. So these trusts qualified under the IRS code. My problem is right here. Such entity, let's see if there was inadvertent terminations. Let's look at this, what do you want to call it? Waffle language, okay? You know waffling? They put the waffle language in here. Inadvertent terminations. Is such entity and each person holding an interest in such entity at any time during the period specified pursuant to this subsection agrees to make such adjustments consistent with the treatment of an entity as a REMIC or a C corporation as may be required by the Secretary of the Treasury with respect to such period, then notwithstanding the terminating event, such entity shall still be treated as a REMIC. Is that waffle language or what? In other words, you didn't do it right, you didn't become a REMIC, but no, if the Secretary says it's okay, then you're still a REMIC. Do you get that in your tax code? If you don't do something, do you get that waffle language? No, you don't. But certainly they did. But this is one of the arguments that if you don't follow this and they haven't transferred this, then why are they provided this tax status from here on after when they started the trust? Right? So what are you asking for in discovery? The trust tax documents. Trust tax. You hit them where it hurts. Where will it hurt? If they have to pay taxes on it. Do you think if you ask in discovery for tax documents that document the fact that they're saying that this is a REMIC when they didn't have all the notes and mortgages transferred? Do you think that they might be willing to come to the table? Are we talking leverage here? Yeah, we're talking leverage. It's always about what can we do to leverage them to get to the negotiation table. And again, it's not we're not looking for the home run. We're not looking for the complete dissolution of the mortgage. There's a woman in April Charney, is a fairly known person that has spoke a lot on this. She works for Jacksonville Legal Services, and she's done quite well. I went to her 2-day event, and I was saying quiet title, quiet title, quiet title. She says, that's anarchy. And I said, yeah. First, only probably 5% of most people at all would consider this. But at the same time, if that's where the documents lead you, as an attorney, do it, right? Zealous representation of our clients. So if that's where the documents lead you and that's where the conclusions are, then you've got to talk about quiet title, and I don't believe it's anarchy. Yes, sir?
What specific trust tax documents are we asking for? Specifically?
Every trust, and if you look back here, they elect the REMIC status, so you want to ask for the tax documents that the trust has filed. The trust should be filing tax documents. As the owner of the note and mortgage, they should have tax documents.
As at origination?
Yeah. Well, each year they should be filing a tax document.
So the tax return?
Yeah, tax return.
So what, are you threatening to notify the IRS if they're claiming tax-free status but have shown, how are you
I just want to
using
hit them. I just want to, solar plexus, so it's the jab them, keep jabbing them.
I think what she's saying basically is, if you came to me with something, and I said to you, okay, we'll consider that, but let me see your last 5 years tax documents.
Yeah.
You're going to be like, well, why ask me? Why are you asking for that? No, I'm not giving you that.
And there have been some judges who have done protective orders saying, no, you don't have to answer all that. You be prepared to say why you need them. They're going to ask for a protective order perhaps with your discovery request.
Right.
You be prepared to say, I need this because if they call themselves a REMIC, then I want to see how if they have actually done what the IRS requires under this 26 U.S.C. 860D. Okay, that's why. Be prepared though, because I've seen some cases where the court has said, no, you get your protective order because it's too intrusive and it's too this, and the courts are not looking at why. Be prepared to back up your discovery and why you need it. Get around that. They will ask for the protective order. And one of the New York cases I read last night, wasn't it? Did they ask for a protective order? I can't remember. I read a lot of cases. When you read so many cases across so many jurisdictions, it gets a little tough, and you got to remember where it's from.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes.
You're the man! I've been looking for this for weeks.
So in this particular case, though, remember that a REMIC could be a REMIC, but even if it's not a REMIC, it's still a REMIC. That's basically what this is saying in this election. Okay, this is an actual page of a pulling and servicing agreement. I'm sure most of you have seen those, right? So it requires the note in the mortgage. What paragraph? You should know this by heart.
2.0.
2.1. 2.1. Paragraph 2.1 in almost every pulling and servicing agreement requires that the note and mortgage or deed of trust be transferred from the lender to the depositor, to the sponsor seller, to the trustee or custodian. Okay? Almost every one, paragraph 2.1. And this is like a cover page of a pulling and servicing agreement. What actually takes place, and I call this the private side because we all know that it's not been recorded, we all know that it hasn't happened. Instead, it's gone from the lender down to MERS, and then MERS will transfer it, although at some point they were giving it to the servicer, they were giving it here. How many of you, like I said, the one that I was trying to foreclose on where MERS had transferred it 3 times? How many of those were transferred to servicers? Okay, you're supposed to transfer it to the custodian or trustee. So a lot of times the correct way MERS thinks they're doing it is to just transfer it to the trustee. When in reality, in order to be effective, because remember, these are securitizations that were filed with the Securities and Exchange Commission. Okay? It's a security document. If you file something with the Securities and Exchange Commission, don't you think you've got to abide by what you filed, right? So if you're filing with the Securities and Exchange Commission and you're saying, we're going to transfer from the lender to the depositor to the seller, sponsor, to the trustee, don't you think you better do it? You would think so. They don't. Not one. Can anyone give me an example of anything you've seen where that's actually happened, right? No, doesn't happen. None of the cases I've seen. Obviously, I just have a small segment. Oliver just has a small segment. But if anyone can ever show me where that's happened, I'd love to see it.
I would love
Because it doesn't. It doesn't happen. The loan servicers work on behalf of the trustees, but they are not the owner. Remember, when you own the debt, you have a right to foreclose. If you don't own the debt, you don't have a right to foreclose, right? It's the debt, the note, the IOU. Remember, a promissory note is just an IOU. I owe you money. The security agreement is just to secure that against the property. And that could have been secured against a boat. It could have been secured against a car. It could have been secured against anything. And frankly, it's got the same issues. If you look at securitizations for cars or securitizations for anything else, they've got the same issues. So a lot of times, if you're doing Fair Debt Collection Practices Act, you will find that they cannot prove the chain of title at all. And that's where a lot of the documentation is sorely lacking. You know, a lot of the people that buy debt cannot prove that documentation. So same thing out there. I know that a lot of people are doing well with Freedom of Information Act cases. We just talked about that. I had lunch with an attorney that's her sole practice is going after the Freedom of Information Act, because you get $2,000 or $3,000 for the client and $2,000 or $3,000 for yourself as an attorney, and she is getting that again and again and again and again. And I think that's another Max Gardner thing, right? Yeah, Max Gardner. So that's probably also where, you know, I think bankruptcy is still a big issue for most of the clients that you're dealing with. That if you're dealing with foreclosures, you probably better know bankruptcy as well, and know it well, because that's where you can bring a lot of those side actions. What happens then is, in the event of default, MERS assigns the mortgage, right? They don't assign it until after the default. MERS assigns the mortgage to the trust. The ownership of the depositor, sponsor, and seller are ignored, totally ignored, even though Securities and Exchange Commission requires it. And that is basically a failed securitization. Some jurisdictions, the court doesn't even look at that, don't think you have standing to look at it, but you've got to keep pounding it in. To me, my job as a litigator on these cases is to instruct the court on what has to happen. You have to keep instructing the court that Your Honor, take a look at this, take a second, take a minute, whatever it takes, Your Honor, this is what we're trying to do. You've got to have, you're probably going to have someone from the trust, or you're probably going to have some kind of witness to testify to all this. That's the hardest part, is can you afford to bring people in to testify? Can you subpoena the people and have them actually say what's actually taking place? You know, the people that work for the banks, you know what's going to happen there. We've got the robo-signers. We've got people saying what's happened. There are some depositions out there, though. Still Google for depositions, because there have been some good depositions where they've actually admitted the faults. And if you can in any way bring those into your case, because you know that average Joe homeowner can't afford these depositions in most cases. They can't afford they can afford maybe the written discovery. Admissions are important. Admissions are extremely important. You want them to admit that they didn't own the note. You want them to admit that they never sold. I mean, and remember admissions, each one, so if we go back, admit that the lender never gave to the depositor. One admission, okay? Admit or deny. Admit that the depositor never transferred to the sponsor seller. Remember, just that one. Don't get into really long ones. You know that won't, they'll say I can't admit or deny because there's too many steps. It's one step admit or deny, one step admit or deny, one step admit or deny. So use your admissions wisely there. I don't know, do you have limits here on admissions?
No.
Good, I love those. I love admissions. And they're actually sometimes admitting things. They're admitting that they don't own the note, they're admitting that they never transferred, they're admitting, so it's a failed securitization. And the pooling and servicing agreement does not allow assignment of defaulted mortgages to a trust because it's usually against the trust rules, okay? Trust usually closes within 90 days. It kind of mimics that REMIC requirement. Almost every pooling and servicing agreement does mimic that. And the REMIC rules requires ownership for a tax-free status. So if it is a REMIC trust, and that's admit or deny it's a REMIC trust. I mean, do that as an admission. Not all of these pools are going to be REMIC trusts. Just remember that. So you need to admit or deny, get an admission on that one as well. And I always love the whistleblower. Did anyone read the article? It was in Bloomberg. I get the Bloomberg magazine on the whistleblower. Did anyone read that? Where she actually worked for the bank and she was told to increase the percentages of she was like quality control, and she was told that quality control needed to allow more securitizations through, and she kept saying, but it's not working, it's not working. And finally, she as an employee was the whistleblower. And I think she got $31 million or something like that. Yeah. Interesting case, but there are some other cases that are whistleblower. I don't know if each trust needs a whistleblower because almost in each case you've got REMIC problems. But with that fudge language that I just showed you on the second part, where it's not a REMIC, but it's going to be a REMIC if we consider it a REMIC, that's where I'm not quite sure if it's worth doing the whistleblowing. How many of you use Bloomberg or have used Bloomberg or know of Bloomberg? Expensive, but good. It's $2,000 a month to have it in your office, so it's an expensive cost. I found that it wasn't cost effective for us. But I'm putting it in here because I wanted to show how this was done. So if someone mentions a Bloomberg audit, this is not a button that you push and Bloomberg gives you something back. This is a terminal that you have access to, that you have to do your own searches. It is $2,000 a month. They don't have a little thing where it says, okay, you can pay $400 a month and that's all you get are the mortgages. You have to buy the whole friggin' thing, which for us made it kind of not cost effective. So instead, because the Securities and Exchange is kind of up there, what is available, we do it on Edgar. We do those kind of searches more. And then if we need some Bloomberg, CFLA has some people that are doing the Bloomberg. But this is, I wanted to make sure that you understood when someone mentions a Bloomberg audit, that it's not something you just ordered from Bloomberg. It's something that you use the Bloomberg terminal. In a Bloomberg terminal, you either can log on to your computer. I think it's called Bloomberg Anywhere, and when I had it, it was like either connected to my thumbprint, and I had to, you do something, and then it shines a light on the computer, and the computer actually can see that somehow. I'm not quite sure. And then you can log on to Bloomberg. The other way that is if we had one computer, as we grew, we just switched it to one computer in our office, and we just had it on that. But like I said, it wasn't cost effective for us. But in Bloomberg, you would look for the original loan amount, the origination date, and the zip code. And in this particular case, for example, we came up with 3 notes that were for $122,500. This is the same mortgage that I used as an example before. So you can see where that particular loan is called paid off. And you can actually go into the first screen that identifies the individual loan with pay history, original loan amount, loan number, etc. So you can see on line, let's see, 122.5. You can see the original loan amount, that very first one. This very first one, if you see it, the 999 means 90 days late, and the F means foreclosure. So if you go down here, you can see 30 days late, current. These are all current. That's how you can read a Bloomberg, but this is the individual. That's the loan number, the pay history, current amount, original amount, and the group. And the group, the 0 or the 1. So if you saw a Bloomberg screen, that's what you would see in this particular mortgage. Then the next mortgage, and this is as you're going across the screen, because the screens can be very, very wide. Sometimes people set up 2 or 3 monitors to see it all. So this is like as you're going across, where you would see the pay history, current amount, and then the modification date. This is good because you can see what loans within that trust have been modified. The rate, the previous rate. So if there's a modification of rate, we knew that initially this was a 6% rate, and now it's gone down to a 4.29% rate. Here's a 5.61, and it's gone down to a 2% rate, and that was done in 11. So you get a sense from Bloomberg of what you can do for your client. It's got the new modification of the principal and interest versus the old modification, or the current, or I guess the original. So your previous principal and interest versus the new principal and interest. Look at this one, where it went. This was all current, but they let it be modified right here, and it's current. It was modified 5/10, and it went from a 7.5 to a 2%. So the PI went from 1894 to 598. Quite a difference. But this is what you can see so that you actually understand the parameters of what might be possible for your clients as well.
Where would it show if there was a principal reduction granted?
There is actually a screen that we can go, let's see if the principal reductions, hang on. And I found that only on commercial, where I can see where the principal reductions were done. I found this only on commercial, which is kind of, I haven't seen too many principal reductions done on the trust, where you can actually see it on Bloomberg. This is confirming the type of loan, if it was, say, what index it was against, how it was adjustable, confirmation of property type, ownership, purpose, and origination. You know, was it an equity takeout? Was it a purchase? So this is when you find something on Bloomberg. And remember, Fannie, Freddie, not on Bloomberg. Jenny, not on Bloomberg. It's only the ones that are privately securitized mortgages are going to be on Bloomberg. And in most cases, unless you've got a really big office, I'm sad to say I don't know if you can justify the cost. This is the tranche list. We identified this loan in A1A. The group number is an identifier. 0 equals all. So in other words, this particular mortgage with a 0 meant that it had payments in all different tranches, which was, so if we had 19 tranches here, you see the number 19 down here? Each of these is a tranche. You can see where these tranches were paid. And these tranches are yet to be paid, are being paid on right now. So this is how this loan was divided up. Does that divide up ownership? No. And a lot of people initially argued that if you had the tranche, that it was so sliced up that it divided up ownership. It's the same trust that owns it. So just like I can buy partial mortgages, that's what the tranche basically is. It doesn't destroy the value of the mortgage, which is the asset, if they actually owned it. Okay, if they had done it right, would this be the argument? No, but if they had actually transferred it the way, the fact that they sold off mortgages, it doesn't destroy the mortgage because I can buy a partial, you can buy a partial, you can buy a partial. It depends on which part of the mortgage you buy. You can split a note up into all kinds of ways. You can split it crosswise. In other words, maybe right now you're paying $500 a month and you sell off the top part of your payment. So I get $250, someone else gets $250. You can sell it that way. And so these tranches don't really affect the fact that these mortgages were being sliced and diced this way. To me, they don't. I know that some people have tried to say that the ownership would be affected. I think it's an extremely poor argument. I don't buy that because I understand what I do with mortgages. As long as it was owned by the same entity, they can slice it up however they want to their investors. Description of the tranche security, the prospectus, and the documentation that were available here. This is like the summary screen that you would see in Bloomberg. Yes, sir.
So my one question is along the lines of what you were just saying. But wouldn't theoretically you, as the owner of a tranche, be the proper party to sue? Because just like when you're buying a part of a mortgage, let's just say,
well,
you could still foreclose. Can't you just make that argument that the proper party is the person who actually, the trust itself is not out anything because somebody's already purchased it from them, essentially. The owner of the tranche is the one who actually is out any amount of money.
No, but they're saying this is a security, okay? So if I go in and I'm thinking of, if I'm IBM and I have 50,000 shares and I've sold 50,000 shares to investors, and those can be different kinds of shares, right? You can have priority shares, preferred shares, different. That still is IBM, and it's still IBM that has the right to enforce or do that. That's where you've got to take a look at it. I don't think you have that individual right. I don't think it's the investors that have to sue. I still think it's the IBM that has to sue. It's the trust that has to sue. That's my perspective on it.
Or couldn't just the argument be made that, and this is sort of what I like looking into as far as, lender private mortgage insurance, things like that, that even if they did have the standing to sue, let's just say, the amounts that they're alleging are not the actual full amounts because there's other people who have reimbursed them in a certain way that even though the debt is this big, they actually are only out a smaller amount.
I think that's a better argument because if they've already been reimbursed it, you can't double dip.
Right, credit default swaps, any type of insurance policies on default
and then that's
loans.
again, where do we find that out? Discovery.
Right.
Right, and you ask about that in discovery. I think that's a much better argument than saying, well, they don't have standing to bring it because they've divided this up. If they've been reimbursed for something already, then it's the person who's been has reimbursed them that has now the standing.
Right.
Basically, the standing is their shoes and should come in.
Okay.
That's my opinion. Yes, sir.
I use the Bloomberg system to attack the Internal Revenue Service on 1099C A8. That's the fact that when a client has no obligation to pay for forgiveness of debt, since the debt was paid.
Explain that more.
In other words, when you go into a foreclosure or you lose, the bank takes back the property. In the year, you're going to get a 1099 saying that you owe X amount of dollars because the bank lost money because they forgave the debt.
Right.
Using Bloomberg, I'm showing that the fact that they didn't lose any money, that they got reimbursed, and in fact, maybe reimbursed more than they should have been reimbursed because they have multiple reimbursements. My client has no debt on that property, and they should have never received it.
Because it was collateralized.
Right.
Right. Do you hear that? Okay, good argument. I like that.
We usually, down in my office, we use does anyone take an approach, the same thing from the accounting standpoint, as far as securitization is concerned?
They were already fully insured, so they were paid off.
They were paid off. So what happens is, person gets a note, a mortgage. The lender gets paid me at closing, right? From the trust or whatever else. That money that the lender gets, they may not be reporting that on their actual accounting sheet. They'll do an off-the-book entry. So it never shows that they have paid. But we asked for the off-the-book information. They didn't give it to us, but we got a principal reduction.
Leverage again. So,
Okay? So
yeah, the discovery can create that leverage.
yeah, the whole idea of that was knowing that the whole process is flawed on itself. They got
Right.
paid. If they got paid, then you can't be a brain freeze real quick.
They can give you a 1099.
Correct.
They can't give you 1099, or can they show that they have a loss?
Correct.
Which they usually sell.
We didn't.
Right. Right.
They never had.
Also on Bloomberg's, here's screen A, structured finance notes to have, these are the related parties, so that you can all obviously learn. Most, for example, if you're trying to match this up, you see that Mortgage Lenders Network is USA. Remember that Mortgage Lenders Network USA was my original lender on my note mortgage, because I'm using the same case in each case. I've used the same person's note each kind of time. You can see that most of the mortgages in this case came through one of these three companies. And they even show you the percentage of what was there. So this is how you can match it up. Yes,
Really
sir.
quickly, before you go to the next page, I want to point one more thing out about that page. Can you go back to that one?
Sure.
If you look at the bottom right, you see where it says swap counterparty?
Yeah.
That's the company that issued the credit default swap insurance, if you will, Bear Stearns.
So you can do a third-party discovery request
Through Bear Stearns.
to Bear Stearns. So right here, is this something CFLA is giving us?
We are. If it's available in Bloomberg, when you order the Bloomberg audits, that will, it'll be a part of it. We do a credit default swap analysis. I always say just order the Bloomberg audit, and if it's there, we'll give it to you.
Yeah. So it's important to see that screen. Do it again. It goes back to discovery. Third-party discovery. What are you asking for here? You're asking for any kind of reimbursement on this trust to the trust, the SVHE 2007-1 trust. Okay. Be very specific about it and be ready to be prepared that they're going to try to do a protective order, so that they don't have to answer the questions, because they'll just say it's foolish and overzealous or whatever. Be ready to fight it. Yes, sir.
Right, going back to that whole argument, how they defend against that is that their reimbursement was pursuant to a different set of incidents occurring, a contract with a third party. So how do you guys use that argument?
Well, I mean, you can't come in and say, I have lost this money and I need to be reimbursed for it when you've been paid that money.
Well, no, but there's
You can't double dip in court.
They're foreclosing and on a note that you signed. Your debtor went into a contract to reimburse the bank for this money.
Right. But haven't they assigned that debt through this reimbursement? In most cases, there's a right, what is it called? Come on, you PI people. If I pay off something, then they have a right. Yeah, right of subrogation.
Oh, okay, so that's how you,
Think about that. If Bear Stearns has come in and paid them off, don't Bear Stearns owns the right of subrogation, don't they?
Gotcha.
Right?
That's what
Not that trust.
Gotcha.
So that's the question: is who has the standing to come in and bring the note in? It's all again.
Relative. Gotcha.
Authority, standing. Those are the two key words that we're talking about today: is authority and standing.
But that opens then a tremendous area also, because the subrogation agreement might not have the right for them to go and foreclose, and it is. So it is a subrogation is a very, very, and it's very important in bankruptcy. Okay. bankruptcy
Yeah.
court. So it is a very important area to look into.
Right.
And that answers something which I was looking for.
Okay.
Because as I said in discussion here, the majority of the judges in appellate division, let's suppose you have a situation which you win, and then they appeal. The majority of the appellate division judges, they are very worried about, your clients getting away with murder.
Your client's not paying their mortgage.
It's not, yes, he received money for the refinancing,
Right.
he used this, all of this, and now because the bank failed in doing certain things with respect to the.
You think I should get the house for free?
Yeah.
And that just grates on the judges. Grates on them.
And understand, as I have said to some of you, they are not going to change common law, but many of these things in mortgage and are statutory, and they can be a lot of interpretation.
Yeah.
And they are being, that is what worries me about the Massachusetts. It is not the outcome, because the outcome really doesn't mean anything, except for people that have that particular type of set situation and dog. But it opens the idea, clearly, which is there, but in which they are struggling, how we are going to find a way in which these people do not get away with murder because they receive the money.
Right. So this is
So
a good way.
if we can prove, okay, that in reality they are not getting away with murder,
Right.
the one that is getting away with murder is the trust.
Because they don't know the
they have
rights.
received the money
They
and now
don't
they are
even-
double dipping.
Right.
It's a different amount.
Right. Because you know that the court won't allow the double dipping. The court may allow Bear Stearns to come in now. If they want to interplead. We'd have to see what the agreement, though. We'd have to see what the agreement is.
Open up another door.
But it does. Do you think they want to litigate this, or do you think they might be talking about principal reductions now? Do you think they want to? Do you think New York firms? What are they? I mean, bankruptcy now. We're seeing some of the bigger firms charging $1,000 an hour. We're all underpaid in here, aren't we? Do you think they want to litigate that with, in most cases, the firms that are going to be representing these people on these may be charging $300, $400 an hour. So do you think they want to do that, or do you think they'll just come in and say, okay, let's just reset it? Because what if they had a short sale? The short sales are going at 81, 82% of current market value. Why not just set it at 80% of current market value? Bingo, we're done. That's what they're doing on a short sale. Why not allow them to stay in their home? And if that's the case.
The argument on, I don't know what the relation with credit default and PMI is, but I would take the position, if you have PMI and you're paying that through your mortgage insurance, your mortgage payment, and you default, the bank gets paid back. I would argue to the judge saying, wait a minute, I bought insurance to cover me for this. Maybe I defaulted, but I was insured for it.
So we've got a couple different subrogation issues, don't we? Yeah, we got the PMI subrogation, and we've got the credit default swap subrogation.
So I don't think the judges should be taking the attitude saying, well, they're getting their house for free. Well, no, the bank got paid off through the PMI and maybe the credit default, and you paid for the insurance for the PMI.
Right.
So why shouldn't you get it? Just because you defaulted, you insure yourself against.
The PMI come from the dilemma up to you.
That might be. You never know.
But if they have a right of subrogation, then let them come after you, right?
The thing is, I think the banks
Let
are
them interplead,
foreclosing
let
and they're
them-
still taking the PMI money, and they're double dipping on a regular basis.
Yes, sir.
I know we want to close this out, but even with the credit default swap, Bear Stearns, it pays when a fraction of the loans go into default. So the whole class doesn't have to go into default. So
Right.
I don't know what the magic number is. Let's say it's 20%. So if 20% of the loans in that particular asset class, their insurance defaults, they have to pay the whole class or all the tranches in that class. So just an additional piece of information, I'll say probably, if I take an educated guess, 90% of the time, they're made whole early into the securitization process. Maybe within the first 3 years of the securitization process, they've been made whole through credit default swap insurance. Bear Stearns going to stand up and probably say to them, do something with these people before they figure us out. We're not going to go in the hole. Very sharp man runs Bear Stearns. He's not going to allow that to happen. So they'll probably push back and push the lenders to That's what it does.
Again, it's creating the leverage again.
Absolutely.
Right, creating the leverage. Now, for securitization, you need certain documents. I just want to go over those. The mortgage note, the deed of trust, and the mortgage. The asset sale and purchase agreements, true sales, legal opinions. In other words, each of those, from the lender to the depositor to the seller, all those have to be true sales under REMIC and under the pooling and servicing agreement. Pooling and servicing agreement, master servicing agreements, all of these are helpful when we're doing securitization audits. When CFLA is doing securitization audits, when you're doing securitization audits, you need to see all this documentation. Pooling and servicing agreement, paragraph 2.1, transfers all right, title, and interest of the depositor. Such assignments includes all interest and principal due the depositor or the servicer after the related cutoff date with respect to the mortgage loans. So if you go up here and actually read this, it will say the depositor. So it actually had to be sent to the depositor first, right? Transferred from the lender to the depositor. The depositor, concurrently with the execution and delivery hereof, does hereby transfer, assign, set over, and otherwise convey to trust to the trustee without recourse for the benefit of the certificate holders while the right, title, and interest of the depositor, including any security interest therein for the benefit of the depositor, and into one, each mortgage loan identified on the mortgage loan schedule, including the related cutoff date principal balance, all interest accruing thereon, and after the cutoff date, and all collections in respect of interest and principal due after the cutoff date. Properties which secured each such mortgage loan, which had been acquired by foreclosure or deed in lieu of foreclosure. In other words, they've taken into account that, on the cutoff date, there might have been something, maybe they first payment and they didn't pay anything. I kind of doubt if they would have had time to foreclose during that time, but they've even taken that into account. So this clearly states that if you're in a securitization, that what had to happen? Everything had to move into that trust. Everything had to be transferred. That means what? The endorsement on the note and the assignment of the mortgage. Show me one mortgage that was assigned timely. Now, the notes are being tough because most endorsements on notes, remember that endorsements on notes are usually not dated, and that's a problem. But I'll show you where I think they should be dated in almost every case, unless they're under UCC 3 negotiable instruments. And that's where we get into UCC issues. And we're just going to touch on this. And let me get this paper first. November 14th, 2011. November 14th, 2011. Look for the report on the permanent editorial board for UCC. Okay? I love this. This one is good.
Repeat that?
It's the application of the UCC to the selected issues related to mortgage notes. And it's by the American Law Institute and the National Conference of Commissioners on the Uniform State Laws. And what's important about this, and I hope I've got the one that's underlined so I can find this real quick. This takes you through a lot of scenarios. But the key is the American Law Institute thought, this is the very first paragraph, just let me read it to you. Recent economic developments have brought to the forefront complex legal issues about the enforcement and collection of mortgage debt. Many of these issues are governed by local real property law and local rules of foreclosure procedure, but others are addressed in a uniform way throughout the United States by provisions of the Uniform Commercial Code. Although the UCC provisions are settled law, it has become apparent that not all courts and attorneys are familiar with them. In addition, the complexity of the rules has proved daunting. So this is supposed to be a clarification of the UCC. And I think it's important that you read this if you're taking a look at it. Now, what is UCC 3, right? It's negotiable instruments. What's a negotiable instrument? The first thing you need to think about is a check, right? We use those at most of us. It's very rare that I write checks anymore. I don't know about you. It's very rare that I'll write a check because I use ACH, I use, bank transfers, whatever. But when you write that check, what do you do on the back? They endorse it on the back. Okay, a client writes you a check, you endorse it on the back. If it's a negotiable instrument, everything about that transfer should be in those four corners, right? Kind of a four-corner doctrine. So if I say, pay to the order of $1,000 to Westerfield and Associates, and I sign it on the back, I should be able to cash that check, right? What if I say, pay to the order of $1,000, but at an interest rate that's in an index that's over here that you're going to have to take a look at? Because whenever you want to cash this check, it's going to be affected by this outside rate, this LIBOR rate. Is that a negotiable instrument? That's the question. Does it become a negotiable instrument when I look outside the four corners of that document? Now, this is very simplistic, and I want you to read this because it gets a little more complicated, but that's a pretty long course, right? Max Gardner teaches this. But let's look at UCC 9. What's UCC 9? That's for secured transactions. Are mortgages covered under secured transactions? Yes, they are. How many judges have said, well, they've endorsed the note, that should be good enough? Have you looked at those? In almost every case that you've got an adjustable rate mortgage or an adjustable rate note, right? It's the note that's adjustable. So an adjustable rate note, and what does it refer to? An outside index? Could I just sign it on the back like a check? Like which is what a negotiable instrument you can do. You can endorse it on the back. Can I do that? No, because I've got an outside index here. So most of those that are under UCC 9 are secured instruments, are secured transactions. And as a security, a mortgage note must have a written assignment for each transfer. Do I see written assignments for a note? Do I ever see a written assignment for a note? No. Never. Never, never, never. And it's not just a mortgage, it's any secured transaction. Like if it's under Article 9, it needs to have a written assignment for each transfer. UCC applies when the information to enforce the note is the written instrument because this is a negotiable instrument. So if I have the normal 30-year fixed rate and it's the note, this argument probably isn't going to apply because you probably have a pretty good negotiable note, right? That they could endorse it. They could endorse it in blank. They could attach an allonge to it. An allonge is like signing the back of a check, but it's kind of making it a little bit more formal. A lot of those allonges are dated, which is nice. Oliver's going to talk about why the date is becoming very important here in New York. So it's an unconditional promise or order to pay a fixed amount with or without interest or other charges in the described in the promise or order. If it is payable to a bearer or to order at the time it is issued or first comes into possession of the holder, is payable on demand or at a definite time and does not state any other undertaking or instruction by a person promising or ordering payment. In other words, what instruction would you have to do in an adjustable rate note? I'm sorry?
The calculations.
Yeah, you have to go outside the note to figure out the calculation if it's based on an adjustable rate, what's the LIBOR rate, what's the, it's much different. The negotiability of that is affected.
Hey everyone! Are you looking to sue your bank for mortgage fraud or foreclosure fraud? If so, you should call Fraud Stoppers right now, because we'll show you a proven way to help you save time and money and increase your odds of success, getting the legal remedy that you deserve. Remember, when the banks break the law, we break the banks. So call us today. Until then, see ya!
I went in for New York, and I'm not saying I know enough about New York law, but here's your section 3-202 for negotiation. So take a look at that. Words of assignment, condition, waiver, guarantee, limitation, or disclaimer of liability and the likely accompaniment and an endorsement is not effective in its character as an endorsement. Negotiation is the transfer of an instrument in such form that the transfer becomes a holder. If the instrument is payable to order, it is negotiated by delivery with any necessary endorsement. If payable to bearer, it is negotiated by delivery. No, this is New York statutes. UCC 9, how do you assign under UCC 9 in the state of New York? And again, I'm not saying I just want you to take a look at it and consider this. An assignment reflected on initial financing. In most cases, the assignment, and I love this, a mailing address. Did you see this? Provides the name and mailing address to the assignee. Have you ever seen a mailing address on an assignee? No. Is it fatally flawed? You argue it in court. Is it another tool in your toolbox for leverage? Yes, it is. Yes, it is. So the question is whether we've got a security or whether we've got a negotiable instrument. So UCC 3 is negotiable. UCC 9, and I have to say, secure transactions. Who had secure transactions as your very favorite class?
It's my hair.
Yours was. Good for you. This was the last, I can still remember secure transactions. I worked full-time as a paralegal to a big law firm. And when was secure transactions available to me? On a Thursday afternoon. So did I want to practice real law as a, working as a law clerk, or did I want to go into my secure transaction class? I liked being in that law firm, so did I miss a lot of secure transaction classes? Yes, I did.
Bankruptcy center.
Yeah. So sometimes karma comes back to bite you. That was my least favorite class because I didn't want to go to it on a Thursday afternoon. And it was the dean of the law school that taught it. So, but we all need to go back to UCC class, secure transactions class. And really study what you've got. Read the thing that I just had from the UCC, and they give a lot of examples in there to determine, and you may have some case law in New York to determine whether it is a UCC 3 or a UCC 9. So read it. The case law may not be right. You may have to start from scratch because, as they were saying, they think it's been interpreted wrong by judges. So take a look at that. Before we break for lunch, they wanted to talk about.
Let me see.
Yeah. Do we have any questions while she's coming in? Yeah.
Just give the note of the article that.
Oh, sure. Once more. Oh, that's right here. It's the report of the Permanent Editorial Board of the UCC, of the Uniform Commercial Code. And when you go through it, it says, as enlightening as your secure transaction classes always were. But it gives, for example, here's page 7, and it gives 5 different illustrations. If you've got this, then you've got that. And it talks about payee is the holder of the note, and therefore is the person entitled to enforce it. Transferee is the holder of the note, and therefore is the person entitled to enforce it. And it gives the sections of the UCC that would apply. So when you're doing summary judgments or a motion to dismiss or something like that, we're going to talk about how to use some of this. It's going to be quite important that you can even cite back. I think this is a good article to cite back to because judges might like reading it.
You have to get the website. Download it.
Google it, it'll come up as a PDF, honestly.
What was the phrase?
Report of the Permanent Editorial Board for the Uniform Commercial Code. It's the application of Uniform Commercial Code to selected issues related to mortgage notes.
Raise a good critique of also levity.
I'm sorry?
Levity has a good critique of that.
Levity? Okay.
Levity. L-E-V-I-T-I-N.
Levitine, okay. But I think a judge would love to see this because obviously judges want to be citing from something of some authority, and I think this carries, although not a case citation, it's very similar to maybe a law review, actually better than a law review because you're talking about attorneys that serve on this committee are well versed and experienced in UCC transactions. So I think it should have a lot of weight. Yes, sir.
I've been starting to start lawsuits against banks for clients who are current,
Okay. For what?
paying their taxes, failure to modify their loans under TARP, and I'm coming in as a good guy and citing violations of who owns their loan and who doesn't own the loan. And they're attempting to settle to adjust their mortgage.
So it's very similar to a quiet, as a good guy.
See, the problem is, you're a bad guy because you're considered a deadbeat, trying to look.
Well, that's the thing, the quiet title, when I say I want them to be paying, I want them to be current if at all possible.
I start the lawsuit against the bank for failure to negotiate, modify my loan. First thing the bank says to me, you're not 3 months behind, you don't qualify for this, you don't qualify for that. I said, my guy pays his loan, why shouldn't he get the benefit of people who are?
Yeah, the same benefit. You're not allowed to
And
discriminate.
they don't want my case going further.
Yeah, and frankly, I find that you almost have to file the lawsuit. When I first started doing this, I thought, we'll negotiate this. We've got enough leverage, we can negotiate this. I was wrong, and I had 7 steps of quiet title, and most of those were, let's see if we can get them to the negotiation table. File the damn lawsuit. Just file it. Because that's when you get, that's when they have to start getting out a $10,000 retainer to actually get a non-foreclosure mill firm to represent them. So that's good. I give you the floor. Oh, sure.
My concern is if I bring these issues up in a counter claim, I'm worried that the judge is going to think that I'm nitpicking if I bring all these little issues up with the UCC, non-UCC 3. Are there any cases that interpret? They are.
Yeah, and I don't know about New York. Yeah, but there are some cases that talk about it, and I'll be glad to share those with you. I would appreciate it. And I always encourage what I call this kitchen sink complaint. I know judges get upset and they're like, well, pick which one. But it's like, Your Honor, I have a right to have alternative theories. I have a right to do that. But that gives you, if then you can get back into negotiation with who you're suing or the bank, that just shows that it's okay if I throw out a couple. When you negotiate, you always come in with things that you're okay to toss, right? As a good negotiator, you have to know exactly where you can cut, but have them there. I mean, if you can, have them there. And not all clients will document the fact that they have fair debt collection practices problems. They won't document it so you don't have it. Or maybe you haven't, the securitization audits, maybe you haven't gotten the documentation, on the forensic loan audit. Maybe you don't have the documentation on the forensic side. But when you can, use it. And if you need, I'll talk about how we do it generally. I usually end up amending a complaint because I actually just want to get it on the record. I like very simple, quiet titles. I want to get it on the record because that's when the negotiations can start. And usually that's when you can get something done. If they want to litigate it, then you got to probably amend the complaint with a lot more, because you want to get it so that you have a lot more coming out of it. There are some quiet titles that have come through as defaults, but there's not been enough time to go take it through the system. Foreclosures in Florida are now at 619 days. So that's to take an average foreclosure. Now there is a way to do it. When I do my foreclosures, there is a way to do it, but you can get it done in 60 days. But there are very few foreclosure mills that are doing that. So, anyone else before we? No? Okay. Okay, welcome back. Hope you had a good
All
month.
my clients' money on finance. I'd rather attack it.
Let's go. Let's start. I can't talk over you because my voice isn't going to last if I do. Thank you. Okay, what are we going to talk about next is the litigation side of it. And how many of you do you consider yourself litigators in here? Big majority of you are you consider yourself litigators, and that's what I did. That's what I do. And I'm actually, because I have my own little notes that I foreclose on, and I also represent clients, it's nice to see both sides and to know where the pitfalls are. And I think that's what we have to look at today. The first question is, what is a quiet title action? In almost every state, it's considered a declaratory action, a declaratory judgment. And this keeps me out of foreclosure courts, by the way, by looking. I mean, we're arguing, for example, the Tampa, it's called Hillsborough County. They wanted us to come up with $1,900 for every filing that we were doing for a quiet title claim. And we said, no, this is not foreclosure. This is quiet title, so it's a civil action. And civil actions are only $400 versus $1,900 filing fee. Yes, the courts in Florida support themselves, so that's why our filing fees are outrageous. But where to go for any definition these days but Wikipedia? It's not Black's Law Dictionary, but it serves us still. So an action to quiet title is a lawsuit brought in court having jurisdiction over the land disputes in order to establish a party's title to real property against anyone and everyone, and thus quiet any challenges, claims to the title. And as I say, an easy way to explain to your clients is you're asking anyone that has anything on record to either put up your documents or to shut up. Okay, and that's how they can remember the quiet title part. Put up or shut up, and that's how you quiet title. It's also known as clear title. Massachusetts calls it tri-title. So the vernacular is a little different in some jurisdictions. I'm assuming New York it's quiet title. Is it called quiet?
There are a number of causes of action.
Okay. Okay, so quiet, we'll just stay with quiet title today. So for some of the current issues, does the mortgage note become a security when it's transferred to the trust? And how does an untimely transfer of the mortgage affect the homeowner? And this is some of the issues with the securitization audits. The question has been, okay, I got a forensic audit, I got a securitization audit, I'm spending this money for my client to show all these things. How can we use these in litigation? And I want to talk about that. Because obviously I'm a big proponent of discovery. You've got to ask your interrogatories, your production of documents, particularly your admissions. You've got to do those admissions. But then if you've done your own discovery or your own investigation into the securitization aspects, the forensic loan aspects, you've got to know how to use that within that as well. So we'll talk about that. There's also been a lot of cases where foreclosure has not been proper, and therefore a title is clouded. Massachusetts, the Ibanez case, where the court, what happened was an investor went in, bought a foreclosure, and then wanted to do a quiet title to make sure that everything was off and there weren't any issues. The court in the Ibanez case, sua sponte, meaning on their own, brought up the issue that because it wasn't properly, and I'm trying to remember exactly, because they didn't actually own the note, that they overturned the foreclosure, and therefore the people that had purchased this property out of foreclosure had no standing. And you better hope that they had title insurance, right?
In New York, there's a specific provision, even after foreclosure, you can go back and undo it if you find they never had standing.
Right. If they never had standing, you can go back in New York, and this is what Oliver's saying, and I'm sure you'll talk more about it when you get to stand up, that if you never had standing, it's the old Brooklyn Bridge thing. How can I sell you the Brooklyn Bridge if I never owned it? How can I foreclose on your property if I never had a right to foreclose? So standing is an issue that can't exist now. That being said, I do have some clients that have hired me to challenge that, because they've come to me, honest to God, 2 years after foreclosure, they came to me and they said, we know that they didn't own it. And I look at it and they didn't own it. They didn't have the documents in place. But the court refused to overturn it because they said that latches, basically. You've waited too long. You can't wait a year or 2 years. You've got to go in as soon as you think there's a problem, or you've got to fight it at that entry level. So that was an Indiana court that I'm dealing with, where when you say if it's an illegal foreclosure, it's illegal foreclosure, the court still may say you just waited too long and tough luck. So it's a tough thing of being able to tell a client, well, I'm sorry, but you just waited too long. In fact, these clients, I even said, I don't think you've got a good case. I discouraged them, but they still wanted to try for it. I wish that they would always hire us when they really needed us, which is when they were first served. Obviously, that's the time. Yes, sir.
Would it follow the statute of limitations of contracts?
I'm sorry?
What would the statute of limitations that the court goes by?
I don't know if there is a statute of limitations per se. What they had done in the case that I had in Indiana is they looked at a paternity case of all things. They honest to God looked at a paternity case and they said, well, if you didn't dispute paternity within a 1 year period after it had been established, that you waived it. And it's hard to argue with the court that kind of comes out of left field and goes, it's a real property case, but we're going to bring a family law issue in. And they didn't want to overturn it because based on a paternity case, it said if you didn't do it within a year, that it still stood.
It would follow like the standard contract law, which what is out here in Illinois, it's 5 years.
Mm-hmm.
I can answer that.
Yeah.
There is a specific provision under Royal Property Actions Procedure Law, Article 15.
Why don't you stand up so they can hear you?
Cancel a mortgage if it's been more than 6 years since the default, because the 6 year statute of limitations until the notice expires. So it's very easy to get a mortgage expunged from the county clerk's records after 6 years.
Okay.
Now in Florida, it's 5 years. So if that was the kind of statute, I mean, once they call it due, and the question is, when is it due? Well, we know it's due by the time they file foreclosure, but sometimes they may give, 3, 6, 9 months notice that it's due. So when does that 5 year statute of limitations start? When does the 6 year statute of limitations start? That's probably going to be the real issue, is when does it start, right? Yeah, that becomes our real issue in most of the cases that we've got, because we've got some people that the note may have become called due 4 years ago, and no foreclosures or maybe foreclosures started, and that's the other question is, just because foreclosure has started, if they haven't completed it, and it's just kind of in never land because nothing's happened, no one's pursuing it, there's a lack of prosecution, does that still count against the 4 or 5, the 5 year statute of limitations? Our argument is certainly it does, and they better get the judgment by then. Now, particularly if it's for for lack of prosecution. That's a big issue, though, is when does it start? When does that 5 year, 6 year period, 5 year in Florida, 6 year in New York start?
It's not when you make your last payment, because the bank has the right to forgive, or
Right. It's not from the last payment. It's from when they call it due. Now, in most cases, if obviously they filed foreclosure, they called it due.
Or they served it in New York and gave notice before.
Yeah. And usually they will serve a default and they will accelerate the note. At that point, it's called due. Yes,
Now,
sir?
do they have to start the action within that time period or obtain the judgment in order for what Oliver was talking about.
They have to commence the action, as you say, action of limitations.
Right, it's a statute of limitations.
So if they
but-
started the foreclosure, then
Yeah,
they're within their time frame.
But in most cases, those foreclosures, they didn't own the copy of the note. They're just sitting there and everyone's afraid to do anything. The homeowner wants to sit there. The homeowner wants to live free in the house. So they don't want to start anything and they don't want to get it dismissed because they like status quo, which status quo means that they can just sit there and hide.
So they might as well just wait the 6 years.
Or 5 years.
Either way, they're gonna wait.
Yeah, so they're hoping that after 5 years, the court will say, you didn't pursue it, you're done, you can't enforce it. 6 years in New York. So that's going to be the real question. Yes, sir.
I filed it in district court under tax fraud, and...
District court under tax fraud?
Yes, because if it's a REMIC violation, I try to create confusion.
Obviously. Not
So basically, when you commit
one at a
tax
time.
fraud, there's no statute of limitations.
Okay, so you're filing it as a tax fraud against the IRS for REMIC fraud?
REMIC fraud and...
In the district court?
District court. I don't go
Federal
to,
district
I don't
court.
go to the IRS. I don't go to U.S. tax standards. I go into district court.
District
since
court.
they're not so clear on tax issues. I shop on the tax issues. You know, sometimes I go to the IRS court, U.S. court, tax court. I'll go into federal district court,
Uh-huh.
a violation of tax code on REMIC.
Uh-huh.
And then it opens up a whole Pandora's box about the problem, and then they try to deal with it.
And are you getting reductions based on that?
I'm getting someone willing to work with me and settle
Right.
my claim, because they don't want to open up.
Again?
You've got to remember, if I find that the REMIC had a dirty loan there,
Yeah.
then I can file a bond, 10% claim on the entire trust. As a
10% of
bounty on
1.7 billion?
Well, the whole trust becomes dirty.
Yeah.
But I have a question to you. Okay, how do you defeat the standing problem of you trying to
I
sue?
create chaos. You know, if I stick on your little standing problem all day long and stay in state court like you like to stay, you got judges who feel like
They don't have to listen anymore.
they don't care.
But you
They don't have to listen.
you have misunderstood my question.
You can't
You are
commit
suing,
fraud,
no,
tax
let me-
fraud.
you are suing in federal court
Yes.
because of a tax
Fraud.
situation, create fraud on credit. But what is the standing of your client that is a
You got a 1099, didn't he?
Did he get it? You mean
Yes, we
after
know we got
foreclosure?
99.
Go.
Yes.
Okay.
After foreclosure, before sheriff's sale?
Right.
Oh, I love that. That's a new one for me, actually. After foreclosure,
Not
The
a
before-
deficiency, they get 1099.
so they'll get a 1099, right, for any deficit judgment?
Right,
But before sheriff's sale, before they've lost their interest in the home,
right.
and you file it in district court, do you ask for an injunction on the property, on any
No, I
show?
ask for money. I like money.
You like money?
Money.
I like this stuff. This
You gotta
is great.
remember, in federal court.
Mhm. You get attorney's fees.
Yes, nice.
Yes, there's always attorney's fees in federal court.
Right.
That they do in the English system.
FCCPA violations, because they may have been the wrong person suing you too.
What kind of violations?
FDCPA.
What did
The
you say?
wrong plaintiff.
FCP.
Oh, FTC, okay. Fair practices. Fair debt collection practices.
But is-
You keep building on it. It's another kitchen sink thing.
Oh, I love it.
Just keep adding on to it. Yeah.
The digital age has closed the gap between information and its accessibility. And it turns out that filing for bankruptcy doesn't have to be as difficult and expensive as it used to be. Introducing Fraud Stoppers, Private Members Association. As a private members association, Fraud Stoppers has helped countless American homeowners achieve financial freedom and the legal remedy they deserve. Fraud Stoppers specializes in cutting-edge foreclosure defense. We offer homeowners state-of-the-art countermeasures to foreclosure with turnkey lawsuit and evidence packages designed to help you get clear and marketable title to your real estate. Fraud Stoppers Private Members Association provides you access to a collection of legal documents and resources that can help you stop a foreclosure sale or eviction, sue your lender for mortgage or foreclosure fraud, get a loan modification, file for bankruptcy, and even fix your credit. By completing the form on our website, you'll get instant access to free bankruptcy documents and other legal documents and information that can help you save time and money filing for bankruptcy without an attorney. So take action right now and get the help you need to save your piece of the American dream. Go to fraudstoppers.org/free bankruptcy documents right now. You'll be glad you did. Cheers.
Is he doing that on the 1099 on the second? What are you doing only on the 1099 on the second? You're claiming the tax fraud?
Yeah, it's fraud. Let them resolve it in federal court. Now, when you go into federal court, you don't get your mill lawyers, you know.
Well, you also get a
get
judge
real
that
lawyers.
has real law clerks who actually research real
Yeah, but I get Manhattan lawyers.
statutes.
You know.
You get the expensive $500 an hour lawyers.
Yeah, that clips away a long while.
So that puts them to the negotiation table almost from day one.
Oh, yeah.
Because rather than $500 an hour lawyers and racking up
I get
what is the
Sherman,
principle
Sterling,
of the
Lincoln,
value of
Powell,
that house,
Powell.
that you can get your, and that's what I found. Let's just go on. First, on the quiet title, the first thing I do is what? A title search. Okay? You got to do a title search. You've got to know what's on title. Some of you may do these in-house. I've got a person that does it so cheaply it's not even worth me doing it. I have the ability to run title, but it was cheaper for me just to hire it out on this. I do search as far as possible. Remember, there are a lot of mistakes that have been made. Things were being, at least in Florida, things were being flipped so fast that a lot of release of mortgages were not filed. So where someone may think that they're a first position mortgage, they're not when we do the actual title search. All of those people are my defendants in my quiet title.
You don't do a whole search, just mortgages, right?
No, whole title search. Everybody that's included, HOA fees, homeowners association fees, county, whatever's on there, I'm suing. I'm sorry?
Environmentals, you know?
What?
Environmentals.
Environmentals.
Departmentals, like in New York, like in the city.
Water, sewer. Yeah, if they have a lien.
They have that in New York.
Yeah, if they have a lien, I would. I would sue anyone that has a lien on it. Okay, so that's the first step. Second, and then here's an example of a title search where we came back. Deutsche Bank Trust is trustee for the registered holders of this trust by assignment of mortgage recorded 1/1609, and yet we know that in this particular case, Mr. Partridge got the house, got the mortgage on 1/29/08, so we've got almost a year in between when he actually purchased the house and when they actually assigned the mortgage. So over a year, what does that mean? A pooling and servicing agreement violation and a REMIC violation, right? So I know that almost immediately from my title search by looking at that.
Can you just go back? We're talking about the assignment of mortgage. now,
Right.
Not the note.
Right, because the assignment of mortgages is going to tell you what took place on public record. Notes are never put in there, but at least you can tell by the assignment of mortgage. Even right here, doesn't that on prima facie just basically tell you that they violated the terms of the pooling and servicing agreement? If I pull the pooling and servicing agreement for Soundview Home Loan Trust 2007-1, asset-backed securities for series 2007-1, and I look at section 2.1, what am I going to find? That they were supposed to have transferred that, and if it's a REMIC trust, then they were supposed to do that within the 90 days. Almost every pooling and servicing agreement says you've got to do it within 90 days. And I see it immediately, and I can look that it was not done when it needed to be done. So it's almost an immediate violation. So do your title search first. I don't even see how you can do a quiet title without doing your title search first. You've got to do it. There's just no doubt. But this is, you got to file. Because until you do, and I have to say that I used to teach that. I've said, okay, here are the 7 steps, and negotiate, and send a demand letter, and do this, and do that. balderdash. And this is only because it's on video that I say balderdash. You got to just file, and you've got to be able to create havoc, and you've got to create. The only time that you have leverage is when you're making them hurt, right? And where do they hurt? They hurt in their pocket. And what's going to make them hurt their pocket? It's when they have to pay attorney's fees from Manhattan or from Tampa or from, for the bigger firms, because that's where they're going to hire their attorneys, the $500 an hour, $400 an hour of attorneys. That's where you're going to create your leverage, because as soon as you file, they've got to start defending this for a reason. Now, obviously, the first thing they're going to do is motion to dismiss, right? Because we basically, one, our pleading has to show that we have a right to come in and we got to survive a 12B6. And I hesitated because in Florida it's called something else. In Indiana it's a 12B6. Is it 12B6 here? Okay, so you survive your motion to dismiss. Then you've got to survive probably their summary judgment. And in each case, what are you going to be showing? The 12B6 you have to allege enough in your complaint. And usually with the title search you can allege enough. And then if you have to do a brief in support, then that's when you go to your audits, your forensic audits. And my complaint for quiet title, I do try to keep it very simple, the first one, because I know I can go back and amend based on discovery. And I keep it simple because I just want to keep the people that are of record. I don't want to have the depositor, I don't want to have the depositor and all the other people that are listed in the securitization, because why? They're never of title. They're not ever on title that I've ever seen. I want to keep it very, I almost call this a quiet title, because I want a default judgment, okay? If I can get this through and I can serve, and I've served everyone of record, I go, Your Honor, everybody that's on title has been served, I can prove it, and nobody's responding. Who do you think's of record? Do you think it's the defunct lender? Do you think it's the defunct next person that may have gotten an assignment of mortgage? Do you think they've really updated it? This is particularly true when they're still in payment. Now, if they've defaulted on their mortgage, they usually try to catch up. And they're usually trying to get their documentation in order so that they can sue. But these are particularly good when they haven't defaulted yet, because your public record is not going to have all those transfers. And that's exactly why the $25 billion settlement came out with the Attorney General's office in 49 states. What was it? Oklahoma didn't join. The national mortgage settlement that we talked about earlier is because they didn't file all those things. Well, do you think under the settlement that anyone has been filing those things? No, they wait for a default. So I beg my clients, please do not default. If you have to, just keep trying to pay. Try to pay up until we get into court. Then I may ask them to pay it into court so that they're paying it into, because I don't want a judge saying, well, you borrowed the money, so you got to pay some back. Well, just say, we'll gladly pay it back. But to whom, Your Honor? There's no one that can prove that they have a right to have it. They should put up their documents, or they should shut up and go away. And if they can't prove it, then quiet the title and give me a declaratory judgment of that. That's why we keep it fairly simple. Now, what happens if you've already been sued in foreclosure, if your client's already been sued in foreclosure? Sometimes you've got mandatory counterclaims that you've got to make, right? Okay, so that's when I probably would include the securitization defendants. That's when I would include the depositor and the trustee and everyone else that's been named. Because I do want to make confusion in the court. I want the court to see that these are the people that should have the note, so why aren't they there? So I would, as a counter complaint, I would include all those individuals. Because it is better to create havoc and better to create a lot of, in almost every case, they're not going to have a single attorney, they're going to have multiple attorneys to represent all the different entities. What does that create? It creates leverage. And it's just about trying to create leverage so that your clients have something they can, it's just hitting them in the gut again and again and again so that they will work with you. You're the squeaky wheel. You want them to work with you. Yes, sir?
Do you feel like you have a legal responsibility to notice MERS on your first complaint?
Almost always MERS is part of it. I mean, MERS is almost always, if it's a securitized trust, MERS is named in that initial search. So yeah, I do feel like I have to name MERS, but MERS actually defaults a lot.
Have you noticed that they will actually, that they talk to the servicer after
No.
they give notice? Do you,
No.
do you notice the servicer?
No.
Okay, just
Servicers are servicers. They're not of title. I never notice the servicer. And there's a good reason why I don't want to notice the servicer, right?
Oh, yes.
Servicers actually may know what's going on, but they're not of title, they're not of ownership. I don't, unless someone wants to record something. I have seen where MERS has transferred to a servicer, which then we got the issues of standing, but if they're named and they're on title, then I feel like you've got to serve them. Servicer or not, named, they could be whatever. If their name may be servicer, but they actually may be holders of a note. So you got to be careful with that.
Appears for MERS in almost all the cases I got.
I'm sorry?
The bank appears for MERS as a division to themselves.
Okay, good. If you heard, he just said the bank appears for MERS in all the cases he's got in New York.
I don't even see any actions commenced on behalf of MERS anymore.
Yeah, I had somebody came in, it was 2 years old, and MERS was the plaintiff, and I thought,
Yeah.
this was gone.
Yeah, that's actually, for New York, it's an easy one. And that's obviously how they started out, and that's where all the litigation started. Almost in most cases now, if there's a securitization, it's going to be New York Bank as trustee for, it's going to be Deutsche Bank as trustee for, U.S. Bank as trustee for, and it'll name the trust. So the bad ones, frankly, are when you don't really have the securitization, when they've done it right. And that's when we try to, if we can, we'll try to negotiate the buyout of the note. We have investors that will actually go in and do a short sale, buy out the note, and hold it in trust for 2 years while the client gets their credit back together so that they can refinance it. Yeah. So that's good to have in your pocket if you've got investors. We've got investors that would hold a note for 8 to 10%. So it's not great, but if we can buy out a note very similar to a short sale at 70 to 80%. Most short sales, the average is 81, 82% of current market value, right? So if you have a third party come in and buy it out as a short sale and hold it for a year or 2 or 3 while they get their credit together, then they can stay in their house. But you can't be afraid to file a lawsuit. That's the key here. I tried to think if I could just get leverage, I could do the securitization audits, I could do the forensic audits, I can show all this stuff that they would work with me. Hogwash, they won't. File the damn lawsuit. And that's where you use the audits. Don't bother doing the demand letters. Don't bother doing, have you ever had any luck with any demand letters? I had a beautiful demand letter written. Yeah. I took weeks to write this demand letter. I had treatises and I was citing all the case law that supported my demand letter, et cetera, et cetera, et cetera. Hogwash. No response. Nothing. Nothing.
On the last line of the prior slide, it said filed for assignments of mortgages are what?
Oh, are recorded. Sorry. Filed before the assignment of mortgages are recorded, if you can. Because as soon as it's in default, what happens? The assignments of mortgages, as soon as it goes into default, they start trying to backtrack to make up for what they should have done when this was securitized. Okay? So try to file it before you have to notice. Try to file before foreclosure too, because as soon as you got a foreclosure, you've got a less pendants. As soon as you have a less pendants, who do you have to serve? The people that are foreclosing, because they've got a less pendants. I don't like that. I want to keep this as far away from foreclosure as possible. But sometimes we have to do it just because of timing. You know, if they come into us, we'll fight the foreclosure, but at the same time, we like to start a separate action. We don't like to file it as a counter complaint. It is not a mandatory counter complaint where we are. Is it here? I don't know.
No, I usually file a separate action.
Good. So you can, if they want to consolidate, they can consolidate. But I want my civil court that does not do foreclosures on a normal basis. I want a fresh eye on this where I don't have a board judge that just wants to rubber stamp stuff. So we like to take it into the civil court that generally doesn't do foreclosures. Okay, using audits and litigation, foreclosure loan and securitization audits. We use it at, yes, sir.
Have you had the problem where after the quiet title action, somebody who actually does hold the paper comes back at you and says during your quiet title action, you had some sort of constructive notice to the servicer that your client's dealing with constantly to know that we exist, and therefore after the fact they're going to come back?
We haven't been able to litigate it that far. I mean, remember.
Are you worried about that at all?
Okay. Sure, and this is what I'll tell you. Is in a minute we'll show you what we do to protect them.
Cool.
Because that debt doesn't go away.
Right.
Right? You do a quiet title, you may have got the mortgage off, but the debt's still there, right? And you got to be clear with your clients that the debt's still there, because they'll say, "Well, I thought you were getting me this." And you know how clients are. You promised the world, and you gave me this. So be really careful that they understand that the debt is still going to be there, and how you can. But we'll talk about how we address that. Now, the audits that we've all known about, CFLA. How many of you have gotten CFLA audits? Several. Good. You can use that. I do not attach it to my original complaint, but I will use it in a summary judgment or at the trial stage. In the trial stage, the summary judgment or a motion to dismiss, I think in both cases you could use those securitization audits. Determine if the mortgage obviously is owned by the trust. Participants of the securitization can become, and that's when I said when you're doing like a counter complaint. A counter complaint, that's when you can, I would include those participants. So can I borrow one of your, okay, great.
Don't they object based on hearsay? You just put in the securitization order?
No, you're gonna have to go back and you're gonna have to get affidavits.
Right.
To support it, because frankly, you and I both know that there aren't any affidavits in these securitization. There may be one at the very end, but I don't know if it's sufficient to survive.
They're based in the audit on other people's records, whether it be Fannie Mae, Freddie Mac, Bloomberg terminal. So again, it's a second layer of hearsay. So I question whether the securitization order can really be used, even with their affidavits. I think going to discovery on them, getting directly from the defense.
And that's where the admissions are really good, because you could look at this and say, okay, go in and do a lot of admissions work based on this. Admit or deny that the mortgage nominee beneficiary is Greenpoint Mortgage Funding Inc. Okay, you're admitted to deny that the mortgage trustee is. No, you don't have a trustee here. That's not a good one. Admit or deny that the depositor was Structured Asset Securities Corporation. Admit or deny that Securities Corporation was required to transfer this mortgage note into the trust. Admit or deny. I mean, you can use this knowledge to create some of your discovery requests.
Right. Actually, I used it. I drafted an affidavit, and I actually, for an additional cost, CFLA provides one of their audit experts who will sign the affidavit.
Right.
The one who actually did it.
Right, and that's important with a summary judgment where you don't actually have an oral hearing. You know, if you just create that disputed.
And they do appear as an expert witness as well, at a cost, of course.
Yeah, that's the problem, is that, which is great. It's just the cost. Can your clients afford it?
But the goal is to get a settlement, right? Yeah, absolutely.
And the goal is to survive the summary judgment, so that they're actually going to start talking to you. Because until you survive a motion to dismiss,
But
12B6 or a summary judgment, sometimes they're not going to be willing to actually talk big numbers with you.
And I would never submit that report anyway, because actually that report contains stuff that hurts you.
You got to be careful.
Yeah.
Which things do you think hurt?
There was some, I believe like the first page or something, it'll say that the note was transferred into the trust, and that doesn't help you.
Let's see. Well, it's not clear that this was taken out of a pooling and servicing agreement. Maybe
Actually,
that's the problem.
it's a couple of pages. Well, the reports I've gotten, like all of them have said that the note was transferred, but that the mortgage took a different path. And that's why I never
There's no
submitted-
evidence that it actually was transferred.
Exactly, the physical delivery, which is required in New York, which is why I drafted the affidavit. And
Right.
This is a warning to all Wall Street bankers and mortgage loan servicers. It has come to our attention that the mortgage fraud and foreclosure fraud you are currently committing has reached critical system failure levels, and therefore, you must be stopped by any means necessary. Unfortunately for you bankers, this requires kinetic activities, in conjunction with mass civil litigation actions taken, and criminal felony charges filed directly against you with state and federal grand juries. Make no mistake, we cannot be bought, bribed, threatened, or negotiated with. We have awakened to your crimes and illegal attempts to steal our homes through fraud and deception. We have already begun direct action against you. We will continue until you are defeated. We are everywhere. Act accordingly. We are Fraud Stoppers. www.fraudstoppers.org.
And the other thing, you've got to be careful of the case law they cite.
hey, that's another thing, yes.
Okay. And frankly, if you're a loan auditor, don't cite law. Please don't cite law. I'm just asking because you've not been trained in it. And how many attorneys would say that that's made it more difficult sometimes? Yeah. Don't cite law. Just give me facts. Give me facts that you can put an affidavit together. But when you cite law, you're doing my job, and sometimes you can screw up my job because of not knowing exactly how to argue a case using case law.
You get to say New York law knows what it's anything.
Yeah, this is California.
Yeah.
And U.S. Supreme, Carpenter versus Logan, the U.S. Supreme Court about the division of notes, but it used to cite a trial court in California, and I was like, you guys got to take this out. And it was good for California maybe, but even trial courts, that doesn't create stare decisis, so that's it. But do use these, though, to draft your discovery, because then you know who you're asking for discovery from, and particularly if you're doing a Bloomberg, remember the Bear Stearns case, that you can find out who the swap agreement was, the credit default swaps were with. You can get your third-party people. You can do discovery to your servicers. Obviously, again, we're saying create some basic documents that you can use again and again and again, because if one client's got the issue, probably 50 clients have got the same issue, and if we can do more of a repetitive business that makes it cost-effective for everybody, for all your clients, then that's what you need to generate. And I do have some of that documentation, so Cassandra asked if I could share it, and I don't mind sharing it, and I will send it through to TR. Because I keep a record of when I get a case, like I said, I monitor kind of all 50 states because I want to know what's going on. You kind of almost need to know what's going on because you don't know where that domino effect is going to be. So I just, I have all my New York cases, all my Florida cases, and I just keep them there. So if I can share that with you, I'll see if I can get that out to everybody. Forensic loan audits. I'm typically not a big fan of TILA and RESPA violation cases, but I have seen in some cases that that's the only thing that the court allowed. So as much as I'm not a big fan of it, because in most cases the statute of limitations is already run where you actually can't pursue it. Some QWR cases, we know of an attorney in Florida that's going through small claims court, so it's a smaller filing fee, and they're settling for thousands of dollars, so it's a little money in the client pocket to turn around to help pay for the bigger case. So the QWR cases, the qualified written request cases, when they haven't responded in a timely manner, they're settling those out. It's very similar to the Fair Debt Collection Practices Act cases where, you know, if the client is really keeping good records, you can get some pretty good, a couple $1,000s for your client, a couple $1,000s for yourself, and you can actually fund the bigger cases that way. So that if they can't afford foreclosure representation, because there's so many Fair Debt Collection Practices Act violations and because there's so many QWR violations, that though if you can pursue those to get settlements, then those settlements can then fund what you need to do to help prevent the foreclosure. And again, discovery issues, qualified written requests, real estate, the RESPA violations. QWR are not very effective in most cases. I don't know about you, but I would say 50% of most of our requests, 50% maybe, no return, no nothing, no, particularly if it's Fannie Mae, Freddie Mac. That's just crazy. So Freedom of Information Act requests then go out. But qualified written requests, make sure you get them sent out. Obviously, discovery is better because then you've got an attorney that is actually on top of it. And that's why maybe you could get attorney's fees and sanctions for failure to answer. Huh? Well, then do motion to compel. Motion to compel to get their answer, and motion for attorney's fees. You kind of can't. You got to develop the reputation that you're willing to go to the mat for it. If you don't develop that reputation, they know that they can walk on you. So I'm a big believer that whenever possible, you keep hitting them. Keep hitting them with more and more.
And you can also make a motion at the same time to dismiss the complaint.
For failure to provide adequate discovery, failure to that would be true. But what rule would that be?
It can be for failure to provide your discovery request. You can make it. You can make a discovery to dismiss the claim.
So if they,
the same way you make the failure.
But almost you have to do a motion to compel 2 or 3 times, and at the end, then the court can actually move for dismissal.
No. We have to do a motion to compel 2 or 3 times.
You don't think so?
No. All you have to show is bad faith.
See, most courts I see that you have to do it 2 or 3 times before they're going to do a dismissal.
You ask for a motion to compel first, then.
And then you
motion for dismiss for failure to
preclude.
I'm sorry?
It has to be a motion to preclude.
To
the way I do
preclude.
a motion to preclude any evidence, and basically at that point you don't inquest because they can't provide any evidence anyway, so it has the effect of having a dismissal, but it's a motion to preclude.
You know, if it's a motion to preclude, that actually might be an ability to dismiss with prejudice.
It is.
And if you dismiss with prejudice, what do you got? You got a perfect quiet title case, don't you?
Yes.
Right?
You have to be very consistent with it because you have to have an order. So at the end of the day, the plaintiff is violating the court's own order to produce documents.
Exactly. That's what I'm saying. A motion to compel, and then if there's no motion to compel, a motion to compel again with sanctions, motion to dismiss, but a motion to if we do it to preclude and they give that order, I would think that you've just set them up so that they can't even defend it in another action.
That's correct.
Right?
Yep.
Under New York statutory law, the CPLR, first you get the motion to compel. They don't comply with that, then you go to 3126, and that gives the court the 3 options to the court.
Okay.
One is to preclude, one is to rule the issues in favor of the party seeking discovery. The third is constructive pleading.
Okay. But I like those 3. In most states, that's not the case. So I like that. I like this motion. I've never heard of a motion to preclude, but to me that sets it up for almost a dismissal with prejudice. And if you got a dismissal with prejudice, that means they can never bring a foreclosure action again.
To a certain extent, I can just do a summary judgment. They don't produce the evidence. They lose.
Yeah. Okay, settlement. If you've now filed and let's hope that you've got someone to the table. The first thing, obviously, that you're looking for is what, a principal reduction. Because in most cases, your client wants to stay there. If they can get it so that it's, you know, below fair market value, and they can, the biggest problem for the people in Florida anyway is that whether or not people can actually afford even at fair market value, because so many people have either lost their good paying job or have been downsized and their income won't even justify what they're being downsized to, so they can't keep it. But at least that might give them, if they do a principal reduction, if you can at least put them in a position where they can sell the place, do something where they maybe walk away with some money, or do something that helps. Interest reduction, obviously you saw that on Bloomberg where there were a lot of interest reductions that made a huge difference in the principal and interest payments. Credit report, try to get it paid as agreed. And no 1099 in the settlement. Try to get it so that there's no 1099 issued because it is a litigation settlement. Yes, sir.
But that's much less of an issue with the Mortgage Debt Relief Act, right? Because
yeah, but when is that ending?
2013. At the end of this year.
I thought it ends in this year.
No, it says until 2013. So
right.
Through this year.
Right, through the end of so we only have 6 months.
Unless they extend it again.
December 2013.
It is December 2013.
Through 13? Okay, sorry.
It's an election year. They extend stuff out.
Oh, they figured that one out, huh?
The Article 22?
No, they're talking about 2013, and so that for 1099, if you can show that you were insolvent, right? Is that what
If
you're talking about?
it's a primary residence under a certain, I think it's like under $1.2 million or something like that, then they forgive the gain,
Right.
essentially, on the 1099.
Now, I had a client that actually had a promissory note. This wasn't even on a property, but they wanted to do a forgiveness of debt. And he said, well, if I do that, then they'll issue me a 1099, and it's like I'm paying it anyway. So you got to be really careful with the tax consequences of anything you're entering into. You know, he would have agreed to the settlement, but he's kind of, in that particular case, he only has Social Security, and you can't garnish Social Security. So there was no reason why we would even enter. It's like suing, get a judgment, because otherwise he's not going to agree to anything where you'd be issued a 1099, because it wasn't the mortgage thing. Anyone want us to share any other kind of settlements that you've been looking at or getting besides the principal reductions, interest reduction? You don't have any? You want to share? Sure. Okay.
I just point out the problems on the back end. For example, if you're settling, you don't know if they have the right to sue and settle. Now, let's say you decide you're going to say, well, I'll give you $50,000, and then you satisfy the mortgage.
Oh, we were talking about this at lunch.
Yeah, and I said, well, if I'm satisfying the mortgage, give me back the note.
Yeah.
And they can't do it.
They can't produce
so
the
you
note.
never know if that note holder's still out there coming to sue you, even though you've paid off, you've got a reduction, or you've got settled with the owner of the mortgage.
Mm-hmm.
So it's really hard. I don't know whether do you ever really have a settlement?
Well, we were talking that maybe you need to do an agreed judgment so that you actually have a court judgment
Yeah, what I recommend is my
adjudicating
client
it
title
rather than
let's say we
settlement.
pay you $50,000. I'll move for summary judgment, and you consent to the relief and get the judge to order that the mortgage is invalid and we're canceling it of record.
What?
I said, if we don't know if the mortgage holder, the ones that's suing you in foreclosure, really has the mortgage. So the question is, do they have the right to issue a satisfaction? So what I do with the quiet title, the relief requests the declaratory judgment declaring the mortgage invalid and an order directing the clerk to cancel the mortgage as a record. My proposal is I'll tell them, if we're settling and we're going to give you $50,000 to pay off this thing, we don't know if you have the authority to do that. So I'll move for summary judgment on my quiet title. You consent to the relief and we get the judge to declare this.
Right, then you've got a court order, rather than a settlement that just kind of goes away, and what if someone else pops up, my three merged people on my one foreclosure, they could still go in. So what if you've got other strangers that are wanting to foreclose? Yeah.
I just get updated title.
Updated title? Will they issue it? Will they issue it? I think you've got a good settlement when you can get title insurance. So that might be something, a way to judge whether this is a good enough settlement is send it over to the title company that you work with and say, will you insure this if I've got this judgment? You know, if they'll insure it, you can walk away from it, or they can sell it, or at least they'll have something that shows that they're protected. Yeah.
Yeah, I had a settlement and the bank did not want to say that it was paid as weekly as it was, and they said that would be fraud on their part, and they couldn't do it. What has your response been to that request?
What was that? I've not had that issue come up.
It was a couple of years ago, so maybe if I redo it now, I'll get a different kind of response. It was a while back.
The other thing is, that's the good thing is if you can buy the mortgage, is once you have control of the debt, you can do whatever you need to do as the reporting.
That's right.
Yeah. So I like, if at all possible, if you can get a hold of the debt, or one of your investors can get a hold of the debt to hold the mortgage, then you can go back and clear it up easier because you can report it, payers agreed. And they can always go back and correct on a credit report. You know, because what if there was a misunderstanding? I mean, you got to think about that, because they're allowed to go back and correct credit reports. If there was a problem, they can correct it. And so the misunderstanding was, well, I didn't know who I was supposed to pay the mortgage to. Right?
I understand.
Yeah. Some people, particularly on the strategic defaults, in Florida, at least, there are a lot of people that are still doing strategic defaults because they're $200,000 upside down. The property is not going to regain its value. And it's a totally wasted. I mean, if you look at it from an investment viewpoint, and a lot of property in Florida is held for investment purposes because it's vacation homes, it's second homes, it's, you know, so that's why we have a lot of strategic defaults down there. So they could easily just say, well, I didn't know who to pay it to, so correct my credit report now.
I recommend to my clients that we write three credit agencies and say, I dispute the debt. I dispute they have a valid debt. And then until the matter is determined whether they get foreclosure, the credit's clear.
Well, you hope it's clear. I have to say I've had the worst trouble trying to deal with. I signed mortgages for my company, and they started pulling my credit, even though it was not a personal debt. So I had to freeze my accounts because I didn't want them to keep pulling my credit, because obviously that counts as dings. Every time you pull your credit, it counts as a ding on your credit report. And then I couldn't unfreeze it because they said I didn't live where I had lived for several years, even though I sent, you know, my firstborn child's documentation. I sent every documentation I could possibly be, and Experian still would not say that I lived there. So talk about fair debt credit. I mean, I love it. I'm like the shoemaker that has their shoes. You know, I'm the last one to take care of my own. How many of you would like to sue a credit reporting agency? Because they just wouldn't work with me. I mean, they just said, no, you don't live there. You don't have enough proof. And I had all kinds of bills, everything, to show that I lived there. Freeing their property. Make sure they know that there's an unsecured note. Be clear about it. Make sure that they understand that the first thing they probably need to consider is either asset protection, because you know that those trustees, that trustee from the securitization, because they weren't of record, right? They didn't show up. What, anyone else that didn't show up, you know they're going to ask for a motion to set aside the default. You know they're going to probably seek to somehow recover if it's a valuable enough property. So what do? First, you do asset protection, which means you transfer it into a different trust, a different name, a different, whatever you have to do to transfer it, an LLC, where you've got different ownership. So I initially do the asset protection. The other thing you've got to consider is, for bankruptcy, the problem will be that you've got an asset that's free and clear. So be careful if you do the bankruptcy afterwards. You may have to wait. What is the fraudulent conveyance rules? Usually in Florida it's 4. So 5 years.
We put mechanics in.
What's the best way, and I've talked to people, what is the best way to secure, say you're doing asset protection and they've already been sued. What's the best way to protect your property that has equity? No, never sell it, because then you're transferring it, and that's the fraudulent conveyance.
File your own mortgage on it?
Oh, a reverse mortgage?
No, I just transferred into a life estate.
Yeah, but you know what? They still, that could work, but the best thing is just put a mortgage on it. Slap a mortgage on it. Slap a mortgage on it from a company, an LLC. You're not transferring it.
But that's the mechanics when you would work.
They're very similar, right? I had a client that, in fact, it was my audio-visual guy. He kept saying, my daughter, she's been in 3 accidents, she's under 18, I'm going to get sued. I'm like, yes you are, yes you are, yes you are. Do something, do something, do something. Did he do something? No! So after he was sued, I said, okay, now we can't do the trust thing because you've been sued. What are we going to do instead? We're going to put mortgages on it. We're going to put mortgages on the property. You have no equity now in any of these properties. And that's exactly what we did. So, how's it fraudulent to have a company that he's owned put a mortgage on the company?
You have to have a transaction. It is.
Yeah.
You would have to actually have a transfer of money to the person who owns this property.
There's consideration. There's all kinds of consideration. You don't have, I mean, to have a purchase of a property, you don't have to put any money down on it.
You do that in my
There are ways to do, it's the consideration issue that's probably going to come up. Just make sure you cover the consideration issue. But a mortgage, in fact, I went to a seminar with a guy that did judgment collection, and I asked him the same question, and his answer was also, just put a mortgage on something. I said, and what was the best way to protect it? You protect your equity with mortgages. Yeah.
In regards to the unsecured note, have you seen any cases where, let's say, I don't know whether you're successful in acquiring title, the mortgage declared it invalid, have you seen the trustees come back and sue on the notes?
No, not yet.
Yeah.
But we have seen cases where they're starting to come back to sue for the deficit judgment. That's starting now.
Because a lot of
A lot of vacation homes in Florida.
They don't have the authority under the pooling and servicing agreements to bring these actions. Some of them, they go back and they get modifications to one of the trustees, and everybody involved agrees to the modifications to the servicing agreement. But a lot of them don't provide, yes, the trustee can sue on the note.
Huh.
So that's why I was asking.
It's not come back up.
Yeah. So I know that's always out there, but I've never seen it happen before.
The last, I taught this on May 18th in Boca Raton. And there was a guy that said that he had a client that, I've not represented one, but he had said that they came in and they sued on the deficit judgment. Because obviously with all the vacation homes in Florida, that's going to start coming up. Because it's still a collectible, you know, they'll do proceeding supplementals on those all day long, and particularly with the high net worth individuals. You know, those are, it's kind of a good thing if you want to go and buy a judgment. You think you can collect it, that's the kind of judgment you want to try to get. Because you can't write it off, there's no 1099, I mean, it's there. Okay, let's keep going. I've got you speaking now, I'm a little early, I guess. Anyone want to talk more about the quiet title before we move on?
Can you speak
Yeah.
again about putting a mortgage, is that during the process of the acquired title, or is that after that?
No, this is asset protection afterwards. Okay, you get the best of all worlds and you get a free and clear property, right? That's what's going to happen. You got a free and clear property, but you got a note for $100,000, $200,000. And most people are like, do I have to pay this note? And who do you pay it to? Okay? So the first thing you want to do is make sure that you asset protect this asset now. Because you've got, say the house is worth a couple $100,000, you've got to do something to protect that so that if you've got the judgment of quiet title, you've got a free and clear property. And in most cases, this isn't going to be an issue because what you've done instead is you've worked out some kind of modification, some kind of principal reduction, some kind of interest reduction.
You mean a settlement, right?
A settlement, right. We hope that we can get a settlement. But what if you get that home run and you get the default judgment, the judge orders quiet title, and you've got a free and clear property, and you assume that there might be some people coming out of the woodwork to fight it, right? So what do? You need to do some asset protection. And the asset protection, I would prefer to, at that point, I would prefer to transfer it. I'd like to get it out of the original debtor's name and get it into something else, so you're at least get it from one place to another. I would do the transfer, but then you also may want to put debt on it as well. I mean, what if you sold it to someone and then you held a mortgage back? You don't own the asset, but you own the right to the value of the asset, and that's completely different. Yeah.
Since you brought up the subject of consideration, have you ever seen any cases where that was actually used in the defense?
I'm sorry, you'll have to speak louder.
The matter of consideration,
Uh-huh.
the fact that there really was no money that was actually given.
I've not seen it litigated. Has anyone else seen the litigation issues? No, what do you do when a client comes to you first and they say, I want to sue the bastard, okay? I want to sue the bastard. What do? What's the first thing that you do? You look to see if it's worth suing the bastard. Is there insurance? Do they have assets? Or is this going to be a judgment that's based on principle? Because I say, we can all have our principles, but it costs money. Because it still costs money. If there's nothing to collect from, you've got to make that decision whether to go forward.
In the sense that there was no consideration that the bank actually had paid for that mortgage, for that note.
What do you mean?
I mean, obviously, with a contract, if I got a mortgage, if the bank is going to come, let's say, sue me because they put $100,000 for this house that I signed to,
right.
They really never actually put that $100,000 up.
That's kind of relitigating the whole thing. Wouldn't you much rather have just protected your asset so that if you don't even have to defend that action, where there's nothing they can get? I'm pretty practical that way.
I mean, separate outside of quiet title.
Make it so that it's not attractive for them to sue you. Or to sue your client. I mean, if you have no asset that they can come after, it's just like when a litigation client comes to you and they say, I want to sue this person, for me, I always started with what asset do they have? I don't want just a judgment. Judgments are worthless unless you can collect it.
Right.
Yeah. So make it so it's unattractive for the bank to come back. So that's where if you can transfer it, if you can mortgage it, if you can asset protect it in whatever way possible, and obviously that's a whole nother class, then make it unattractive for them to try to do anything. That's the last place they're going to look instead of just saying, they'll just go next. That you want them just to say next if there isn't an issue. But be prepared for it. I mean, I always tell my client, you're going to end up, if we get the home run, you're going to end up with something you've got to protect because you're still going to have a note out there. And if they get a judgment on the note, what does that do? That becomes a judgment on the house under the same name, right? So you don't want that.
Would you recommend placing the property in an irrevocable trust with somebody
very closely as a beneficiary?
I love those. I love the irrevocable trust.
Over the mortgage.
I do ask for it all day long. I would do irrevocable trust because you usually can find a trustee that's a favorable trustee, brother, sister, mother, whomever. You can find a trustee that's favorable. I would do irrevocable trust all day long.
That would be the number one recommendation.
Yeah, but that's before litigation happens. So that's, yeah. That would definitely be, because those tend to be, judges tend to uphold irrevocable trust. So all day long, yeah. Yes, sir.
When you're doing your quiet title, you were saying that you like to keep things as simple as possible.
I do.
In the later part, you were saying to make sure that you muddy the water as much as you can.
That's if it's a counterclaim. If it's a counterclaim.
All right, so my question is, when you, in your experience, when you filed your initial quiet title, do you really strive to do a bare bones, hey, these are on title, I dispute them, get them off?
Yeah.
And then if they respond, then you...
My pleading's 8 pages long.
How many pages long?
8.
8 pages long.
Yeah, 8 or less. Yeah, I mean, I keep it very simple. And it's just basically, this is what I found, you know, you have to do all your allegations that you have to allege under your quiet title statute. So it's your quiet title statute within your state. And then I bring in what I've done on my title search. And I just say, based on our information and belief, you've got to allege enough that you're going to survive that 12B6 motion. So you've got to come up with a reason why, you know, because I haven't been, this is not the entity that has sought payment, this is not, you know, you have to come up with the reasons why you think that you have a good faith belief to have a quiet title claim.
And you were saying also that in some cases, the allegations may be different.
What do you mean?
From what you've done. So you're following a train of logic, and then you may say, well, this is also wrong.
I'm not following you, I'm sorry.
I'm sorry.
Okay.
I don't want to confuse you.
No, that's okay. I like to keep it simple. I only file it against the people that are of title, on title. So when my title search comes back, any encumbrances that show up on title get sued. Because I want to clear them off. And some may survive, you know, the county may come back and say, yeah, we got a lien. Or, you know, an HOA may come back and say, yeah, we got a lien. But if I can wipe out all the big stuff, I'm happy. And I actually get a success fee for my client, as I said. We go in and if we do I've got some clients that I actually get a percentage. If I do a complete quiet title, I may get 30% of the equity and hold it as a mortgage for 5 years. Yeah. It's not a conflict. It's all it's a success fee that if I get a free and clear title, I may take a third back. Now, would they rather have their property with a third mortgage on it, or would they rather have the property with what they've got? And that's because I've taken a lesser monthly fee. Okay.
And what are the
So
monthly
you're still
fees that
taking,
you
you're still taking fees, right?
Huh?
You're still taking fees besides the 30%.
Some I don't even take a fee because they can't afford anything, and so I work out something with them that's a much higher percentage. Okay. So it's up to you, but it's better than what they got. One of the riverfront property I referred to, they can't afford to pay me anything. They're living hand to mouth right now. But I think it's a good case, so I took it for 60% of anything I can get. And they're friends of mine, so I was probably generous there. But I took it for 60%. Now they're not paying me a dime to do anything, so I better know that I can do it. But, you know, we'll see what happens.
If they can't pay you now, how are they going to pay you 60% later?
No, you sell the property, okay? And it's 60% of the value of the property. So in this particular case, this is a riverfront property that I know that the restaurant next door needs it. And I could probably get $350,000 to $400,000 for it. And if I sell it, You know, if I can get $150,000 to $200,000 for it, I'll take it.
I got you. I assume
Yeah.
they were living in, but.
No, they're gonna have to sell, they're gonna, on the ones like that, they've gotta be willing to walk away from the property. Because we've gotta be able to liquidate
How are
it.
you gonna make sure that it's gonna happen? So they have the right.
Because I have an option. I have an option. I can exercise my option. Yeah. No, I protect myself. And I have investors that come to these workshops and they love that. They start going ching, 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 ching. They like that. And in fact, there's a big firm in Miami that's now, I taught this starting May last year, and there's a big firm that uses my thing, and I'm going, I should have been out there doing that. Sometimes you get so involved in your practice on a day-to-day basis that you're not out making money. Right. That you're involved so much in your practice. I could go and make a lot more if I didn't practice all the time. It's true. It's very true, but you do what you have to do. Yeah.
I know that 99 times out of 100, you do the asset, you do the asset protection, and the trustee or whoever is not coming back after you. Who's going to bear the, do you advise your clients that there is a possibility that someone who is owed the debt is going to come after you, and your legal fees are going to be astronomical? Because they're not just going to say, okay, it's fine. They're going to say, we should have security, so you now holding the mortgage, they're going to come after you. They're going to come after the homeowner. They're going to come after everybody.
Well, the question is, will they?
No, I'm not saying that they will, but they can.
That's why you make it extremely unattractive for them to do so.
Okay.
And that's the whole other course of asset protection. Yeah. And we cross that bridge when we come to it.
So you haven't really seen it yet, and if it did,
that's the problem.
It's a cost of doing business kind of thing, I guess.
Yeah, sometimes. But we're very clear with them that they will have a note that's, the company in South Florida that's taking this is actually creating a mortgage. So they're putting a new mortgage, a second. Have you heard of this? Fidelity?
What they're doing, they're doing second. One company I know, a second mortgage on the property.
A large second mortgage.
And what they're trying to do is sell it to the secondary market as an investment vehicle, just like the banks.
We're doing it over and over again.
I didn't know about the secondary market.
That's they're making it a portfolio property that really has value.
Yeah, these are, I mean, the people that have contacted me have really high-end, they're high net worth individuals that got caught upside down and cannot, like one guy was a litigation attorney and he invested, what did he invest in mortgage-backed securities. Oh, it's like, so I'm so he can't afford his $1 million house anymore. So that's one of the ones that I'm actually doing because it's a great property. We'll see what we can do. So a lot of people there are starting to do it. I need to get away from my practice so that I can do it more. Let's break a little early and come back in 15 minutes. How about that? And then we'll start in on New York law.
I originally started out doing personal injury litigation. Then I started moving into some other commercial litigation. I worked with a firm that was outside counsel to UPS. We did all their local litigation. I started living in real estate, and then I went out on my own. And at that point, I'd do anything with the money coming in. But I started getting mostly into commercial litigation. I've been doing real estate title litigation. I've been doing appointment litigation. And now I'm getting into this. You know, I'm a litigator, and if I see something that can make me money and it's not a risk to work with, this is the kind of stuff I love. So, I don't know.
You don't need it?
Everybody can hear me?
There we go.
All right. Now, the law in New York really is based upon the MERS system. And that's why it's different than most other states. And other states haven't looked at this as detailed. Now, it originally started with a case called MERS Corp against Romaine. And Romaine was the county clerk out in Suffolk County. He refused to accept for recording mortgages that were made in favor of MERS. MERS sued, and it went to the Court of Appeals, and the court ruled yes, he did have to accept it for filing. But there was a dissent, and there was Chief Judge Judith Kay, who says, well, that doesn't mean just because they're getting filed doesn't mean it's enforceable. And that's a question we're leaving for a later day. So that set the stage. Now, Silverberg, the simple proposition of Silverberg is that if you aren't in possession or a owner of both the note and the mortgage at the time you commence the foreclosure, you don't have standing. But it's a little more than that here in New York, because the question is, how do you prove that they have the mortgage and the note, especially in the case where MERS is doing the assignments? Now, it goes originally back to a case of Alderazzi Kings. And I think, you know, it's going to be a little dry at this point, but I think it's important for me to read it to you so you understand the reasoning as to why the courts have ruled that MERS has no authority. Now, first of all, MERS can never assign the note. MERS never has a financial interest in the note. Under their own rules, they never take interest in the note. So they never can assign the note. That comes to the mortgage. What can they do with the mortgage? Well, again, the problem in litigation is you never know that when you go in there, whether the bank is going to turn around and say, yeah, I've got the original mortgage and I've got the original note. And they've endorsed me in blank, or they've taken me with physical delivery with an assignment. I've just talked to another attorney. It's one case where I found there are a couple of situations where that can happen. In this case, it was with IndyMac and One West. And I looked, and the MERS was the mortgagee of record. And the note holder at Fannie Mae, on their lookup, said they had the note. The banks turn around now saying, I got the original note. Apparently, despite if IndyMac always retained the note, even though it was reported to Fannie Mae that they had it, they never assigned the note. So now what I'm looking at is they have a note, it's stamped, it says IndyMac Bank, payable to One West without recourse, and it's signed by someone. That leads me to the problem. I asked him, how are you going to prove that's the original note, absent an expert witness? He's got this in federal court. He wants to make a motion for summary judgment. I said, you're going to file a motion electronically saying, I got the original note. You're going to file a separate copy to the judge saying, I got the original note. Your bank officer is going to testify, oh, this is the original note. I said, really, what's he going to base that testimony on? He's no expert. He has no personal knowledge. Only the person, the original lender who signed that, could testify to that being the original note. Well, apparently, in this case, it's a problem because when the bank is still, the original lender is still in existence, they can turn around and give MERS power to assign. That was a key holding in Silverberg. They said, absent some further authority, MERS does not have power to assign a mortgage. They only have those authorities that are given in the mortgage. They have the right to foreclose, they have the right to collect payments, but nowhere in those mortgages is MERS given the right to assign. And that's what happened in Silverberg. And they said, without that more, you can't assign the mortgage to the present party that's foreclosing, you can't assign it to anybody. So when I look at these cases and they come in, first thing I looked at is it a MERS mortgage? Vast majority of them are MERS mortgages. The second thing I look at is the original lender still in existence? Because then that gives me some confidence to know that they can't get that power of attorney. It was Countrywide, it was WAMU, they can't go back and get this power of attorney. The original lender is still in business, yes they can. Now, just get a little water over here. And again, the court in Silverberg looked at what this word nominee meant. And they said, we don't know. But they did, it's not an agent. Let's see if I can give you the exact quote here. Right. The mortgage provides MERS is acting solely as a nominee for lender and lender's successors and assigns. The mortgage also provides the borrowers and defendants granting convey the property to MERS solely as nominee for lender and lender's successors and assigns, and to the successors and assigns of MERS. Now, in Alderazi 2, the bank came back twice, trying to argue, yeah, we got to sign the mortgage. It's a valid sign of MERS had authority. Second time they came back, the court took a look at all the rules that MERS was working under, their own rules. And the MERS agreement says when the MERS system is not a vehicle for creating or transferring beneficial interests in mortgage loans. That's the rules they operate under and create themselves. So the court looked at that, and that's something I think that they've got to start arguing in all these other jurisdictions. By their own rules, MERS never had the power to assign. Section 6, the MERS agreement provides the MERS should comply with the instructions from the holder of the notes, and that in the absence of instructions from the holder, may rely on instructions from the servicer with respect to transfers of beneficial owner. What the MERS agreements in terms and conditions should provide is that MERS may execute an assignment when instructed to do so by the lender or its servicers. This is nothing more than saying that if it granted authority by the lender or its agent to assign a mortgage, MERS can assign the mortgage on behalf of the lender. Now, there are a lot of things going on here in New York. One, again, we discussed the issue of the burden of proof. And I have a big problem in this quiet title action in federal court. If I go ahead, they're going to file summary judgment, they win, my client's in trouble because it's collateral estoppel and a foreclosure proceeding. I have the burden of proof here. I don't want to be put in a position of doing that to my client. So in the case, it looks like there might be a chance here that they do have the original note and that they can get assignment of the original mortgage. I don't want to take that chance, and I have the burden of proof here, and they aren't even offering me any proof, or any discovery. They're just going to go in and make their summary judgment motion. But they did offer that I discontinue, and that I relitigate in the context of the foreclosure proceeding. I think I'm seriously thinking about it. Because at this point, my client hasn't been served with a 90-day notice. This doesn't look like it's coming. It's got to be 9 months away. So I'm thinking in this case of discontinuing without prejudice. In that case, if it's in the context of a foreclosure proceeding, the bank has the burden of proving its own standing. It's a little strange because I would have thought lack of standing is an affirmative defense. The defendant has to prove it. But the courts in New York have said the bank still has to prove it owns the mortgage and the note, and therefore it still has to prove its own standing. Now, again, let's see, the rule of the chief judge. 2 years ago, I think it was, the chief administrative judge seen the problem with robo-signing in New York, as well as a lot of other problems, in the paperwork that was submitted to justify the foreclosures, the calculation of what's due. The chief judge instituted a rule requiring the bank attorneys to certify when they're asking for the judgment. One, they've checked with all the bank officers and everybody involved, and one, all the paperwork is in order, and two, all the calculations are in order. And if they're not, and they ended up foreclosing, the lawyer was personally liable for all the losses to the homeowner. That stopped foreclosures in New York 2 years ago, basically. Because no attorney was going to sign that affidavit. Because they didn't even, most of them wouldn't trust their own clients. They knew the paperwork was no good. Secondly, what that has done is it's created a shadow docket in New York. The banks have filed tens of thousands of mortgage foreclosure proceedings. And if they get an appearance, they just let it sit there. And they don't want to move ahead on these. Chances are because they don't have the paperwork and they're hoping someday they can get the paperwork. But at least they're not going to blow the statute on this. But I think that, it's probably going to start loosening up again, because I heard that 2 months ago the foreclosure proceedings were 175% in Suffolk County. And so they're starting to crank up again.
What attorneys are going to sign that kind of affidavit that puts them in harm's way based on their client documentation?
I don't know. Obviously, that's why
they're doing it.
I know, that's why those kind of attorneys are getting big money. Yeah, now Stephen J. Baum, he was doing it, and almost all of his paperwork was no good. He got hit with a $2 million fine, and he was suspended, I think, for 2 years from the practice of foreclosure law because he was so crooked. He handled about 60% of the foreclosures in New York, and when he went out of business, now they're just reshuffling these foreclosures all over at other firms. Paperwork's getting lost again. So, will it come up again? I don't know. Now, another issue that, yes, sir.
If, on your cases where it's sitting there, you put in an answer, and now you have a good sense it's just sitting that they don't have the paperwork, are you moving to dismiss?
Well, yes, I'd certainly serve my discovery demands, and and I'll push ahead with discovery. They feel very hard to get them to comply with discovery, as everybody's been saying. They don't want to give up any of these records, so these cases just don't go anywhere.
Are you having any success with conclusion orders and following up on conclusion orders with dismissal motions?
Well, let me explain the issue of the conclusion, which I brought up before. In New York, you have first you have to do in state court, you have to do order compel. Then you have, if they don't comply with that, then you have remedies under CPLR 3126, and it provides 3 separate remedies. Either one, the judge can rule that the other side is precluded from offering evidence on that. But that's not going to help you too much when you have the burden of proof in a quiet title action. The second one is it can rule any issues that the discovery involves ruled in favor of the party demanding discovery. And the third remedy is to strike the pleading. So an order of conclusion really doesn't help you in this quiet title thing. So that's why I like it if I have a foreclosure, unless, and we're both on either side of this. I like to wait until they commence the foreclosure, and then put in the the issue on standing, and then bring a counterclaim to quiet title. And if they can't prove it, then I would say that they don't give the documents. I think there's a fair shot they're going to declare it null and void.
And the only reason I said it differently in Florida is because our filing fees are so exorbitant. $1,900 to file a counterclaim in a foreclosure is prohibitive. But here, I'm assuming that you don't have those kind of filing fees.
No, we don't. We also don't have two separate courts, one for civil cases and one for foreclosures.
So it's different.
Well, I believe that you are, at least in New Jersey and New York, correct, because standing goes to certain jurisdiction and it cannot be waived. And therefore, they have to come and prove a standing by, if not the courts, both in New Jersey and in New York, will keep them out. If you then bring it as a counterclaim of widening the title, they have still to prove their standing on their direct case.
Now, I just saw one guy that made a motion for summary judgment dismissing the foreclosure on grounds of lack of standing. And they're arguing that it shouldn't be with prejudice. Now I'm saying, well, if you don't have the mortgage and the note now, does this mean you can come back and relitigate the same issue again 3 years from now? That's the position taken by this bank.
Well, under the rule of New Jersey, and I don't know to what degree, because although I am a New York attorney, I have not researched that portion of New York. Under the rule of New Jersey, it is dismissed with prejudice the first time. And if the 12-month wait, they don't reinstate the case, then you can make the motion that it is with prejudice. And they better defeat your motion because now they are dead.
Right.
And since you know very well that the reason why you succeeded was because they don't have all of the requirements in order to prove a standing, they are dead. So in certain jurisdictions, and I believe that in New York probably is going to be the same. It is incumbent that the argument that we have of defeating the standing or the authorization, both of them together, is crucial. That we win there, because I believe that the quieting of the title will be much more peaceful after you prove that they don't have a standing.
Quick question. In your discovery and paperwork that they have given, especially dealing with Stephen J. Baum, as all of us who do this kind of work have dealt with, a lot of the assignments have been signed allegedly by MERS vice president, who also worked for the firm that is bringing it. Have you got any cases that have determined that that assignment, because it's an ethical violation where the attorneys on both sides of that transaction, where it's invalidated the assignment?
No, I haven't, but I mean, I guess I didn't go back to the basis of how MERS worked. Even though they process the assignments of almost all the mortgages in the country, there are only about 15 full-time employees.
Right.
But there are hundreds, thousands, tens of thousands, because every title closer and every bank executive is appointed an officer of MERS.
Right.
And they can sign. So is it a conflict of interest? I don't know, because they originated the loan. They're granting the assignment. Why not? I don't think it's a conflict of interest.
It's a conflict of interest, but the defendant can't raise it. Only the person who's in conflict can raise it. So if they're not raising anything, it's not going to help.
Well, how can you not raise it if the attorney, if the law firm, if the person who signed off on the assignment from the original lender as nominee to the new plaintiff is also an employee of the law firm that brings the lawsuit, that first of all, that's an ethical violation.
I don't know if it may be an ethical violation, but I don't know if it's enough to defeat the
I have
assignment.
a couple of decisions already in state court that it may be a conflict, it's not the defendant's right to raise that. It doesn't help. I mean,
What
you
about
can stop
the
a
authority
foreclosure.
issue?
I'm sorry.
What about the authority issue?
Right, and a lot of them won't produce the POA saying that they have the right to
That's why you got
assign.
discovery for.
And usually your corporate statutes are going to set who has authority. And if that person who works for a law firm isn't given the authority through the corporate statute,
But they have created a new system by which they defeat that. Now, the vice president, known out of the 15 people that work only for Merck, now he issued an authorization to people that have been named as vice president of Merck throughout the nation. There are about how many hundreds of vice presidents. Question is, how do we go in fighting that? In
Right,
fighting
but a lot of state statutes will say that you can't issue authority like that. It's got to be one of your corporate officers to sign off on something that kind of substantial asset.
But that is exactly what they are doing. They are creating corporate officers by making one single example is I live in New Jersey. Is an attorney of a law firm which I believe was Fine Such Smith firm. There is an attorney called Rosemary Diamond that is now being sued all over in federal court, in which they named her as a vice president, and she was the one that was signed the assignment, and a law firm was at the same time the one that brought the action.
Feel and Hallinan. Yes, that's exactly
Hallinan,
right.
yeah. So this is the new trend, there are ways to combat it, but I understand that now the weak link in reality is what you said. The fact that Merck can authorize a third party that is an attorney, the one that assigns, doesn't Merck itself as an organization has the right to assign it if it doesn't have the authorization coming from the vendor, from the zero case. And I believe that although these cases are persuasive, the other jurisdictions do not have to follow it, but the language in it is very powerful because it puts one of the seminal cases, which I believe come from Kansas, and use the same language that it did. But that is a portion in there in which I have a tendency to disagree. Doesn't have even the law firm itself the duty to put forward its own guy that is doing this violation of ethics. And to what a degree a violation of ethics can be the basis, not for a contractual bad faith or anything of that nature, but for a tort. I don't know. Okay, that's where we have to be a little bit creative.
One thing strange the way New York courts have looked at it is a gut reaction from me. When I looked at it from a contractual end. And as a mortgagor, you're the one that granted the rights in the mortgage. But New York courts didn't look at it as a contractual matter. They said still the lender has the right to give those assignments, not you. Now, that also brings up, again, we go to the theory of the fact that it never was properly assigned to the pool. It never goes through the sponsor, the custodian, the trustee. Nobody's litigated that here. But the question is the mortgagor a beneficiary, a third-party beneficiary to that agreement? I don't know if they are. But it's certainly something I'm going to try to argue at some point. Another issue, as I raised earlier, I would argue, in defending these cases, is that they've already been paid on this. 90% of these mortgages, all the subprimes, they all had to have primary mortgage insurance. And if you defaulted and they turned it over, they were going to get paid. They may have even got paid on the credit default swap. So the question is, does that affect their standing? Do they have a cause of action because they've been made whole? Now, I'd also argue that some of the judges, and especially the bankruptcy judges, they get pissed when they see more people trying to walk away with their houses free and clear. But it's my argument that, wait a minute, you bought this insurance and you paid for it, and you're the beneficiary of it if you've defaulted, and they get paid. So they got paid, and you had to pay insurance to protect them. It would be almost the same as if you had your auto insurance, and they get paid by the insurer. They can't come and still sue you for it. So I think, that That has not been raised yet in New York, and I think that's a prime issue that is ripe for litigation.
Well, quick question, the credit default swaps, the houses that purchase these credit default swaps, did they purchase it with any of the funds that were generated from these mortgages?
Yeah.
Because that would make them a third-party beneficiary.
So, now, again, I keep going back to the problem with the way the New York City court system is set up, and that the issues of getting into whether or not they get a judgment of foreclosure and whether or not you can challenge their standing is usually done after the settlement conference. And once they put in the motion for a judgment of foreclosure, there's an automatic stay of the proceeding, and it gets sent to the settlement part. And you can't litigate that issue until you get that stay lifted. And to a certain extent, because of as hard it is with the HAMP program and how little it does to really help the homeowner, because maybe you're going to get a reduction in your payments, but when you're getting hit with a $7,500,000 balloon payment at the back end, they're really not helping you any. They're making more money. So, now the other question is, how do you get a modification done if you don't know that they have the right to enforce this mortgage? Let's say, for example, I said they bring a foreclosure. We agree to pay $100,000 in cash, and we have cash to settle this. And they say, fine, we'll give you a satisfaction. One, do they have the power to give you a satisfaction if they didn't have the power to foreclose? Number two, when you normally pay off a mortgage, they give you your original note back. They can't, 90% of the time, they can't give you that note anymore. So is your case ever really settled? Now, I would propose in my quiet title case, that how would you settle with that, even in that context? Because I had an offer very quickly. I offered, I brought the quiet title. He had about $515,000 principal. They immediately offered to reduce the principal to $280,000, and that was a first offer. But I said, well, great. You file a satisfaction. How do I know I'm just dealing with the right party? Number two, if you can't get the note, how do you know the note holder isn't out there and saying, I never approved this settlement, I want the rest of the money? That's why under the pooling and servicing agreement, they need the authority of the trustee to modify the loan. And a lot of the pooling and servicing agreements restrict the trustee's ability to modify those notes. So what I proposed in my case was to, if we were going to pay off, pay the bank and settlement, I would make a motion for summary judgment on my quiet title action, asking for the court to cancel the mortgage of record, declare it null and void, requiring the bank's attorney to consent to the relief of that. And then I have a court order directing that the mortgage be canceled. So then I obviate the problem of whether or not the satisfaction is a good satisfaction or not. I have a court order removing that mortgage from the county clerk's records. Of course, it still doesn't protect you because you still got the note holder out there somewhere. Now, the other problem is I've seen problems of multiple assignments, where MERS assigns the mortgage to one bank, and 2 years later, without getting it signed back, assigns it to another bank. I've seen two banks trying to foreclose on the same mortgage. So it really causes, the MERS system created so many problems in New York. They realized they couldn't deal with it. And the real telling language at the end of the Silverberg decision was, they said, we recognize by rendering this decision that we're invalidating the vast number of almost all mortgages in our state. But we're constrained to do so because that's the law. So then you get to the point, well, what are the banks going to do going forward? How can they fix this? The only way I see is they cannot sell off these notes. They've got to, they put the pool together. They have to change the terms of MERS or stop using MERS altogether. and go back to their valid, written assignments. MERS only was created because the banks claimed, oh, it takes too long for the county clerks to get these assignments recorded, and we can't get, find out what's going on. I've never had a problem out in my county clerk's office. I go out there, it takes me 2 minutes to find all these records.
It's tax evasion.
Yeah, so they're just trying to avoid, paying these fees. So they really shot themselves in the foot. They did it themselves, and they could still go back to the old system of using written assignments of the mortgage and the note and filing these things. Get the original parties and get it, do it properly. Also, I think perhaps if the same bank that has the mortgage also owns the pool of notes and they're the trustee, that might get around this problem. But I don't know, because they really, unless they go back to the old system of using their own money to lend for mortgages, but that's why they started securitizing, because there wasn't enough money in all the banks in the country to float all the mortgages in the United States.
Mr. Boris, securitization is not only was to raise money. They had also to deal with the preference, the avoidance of preference in bankruptcy court. They had to put a distance between the bankruptcy court, the transfer of the money from one of the institutions to the other. Because if that doesn't happen, then the trustee of bankruptcy could avoid the preference and get into the trust. So that solution of having the trust have everything in your hand will be a paradise for the trustee of bankruptcy, because now the money is right there for them to take. So now they are in a bind right now. They have a big problem.
Now, also get another issue that just is coming up lately. I have a number of clients. They don't know they're in foreclosure. I don't know whether the process servers are just using sewer service or not, but I have so many of them coming in. But the problem is even though they do not appear, the banks will make a motion for an order of reference, and they'll get a referee, they'll get their calculations and the report sent back. But when they move for a judgment of foreclosure, that would shut them off. But they don't do that because they don't have the paperwork and they can't sign the certification. So all of a sudden they come to me. And it's 2.5 years after the foreclosure has been commenced. They haven't put in an answer. They haven't got a default judgment against them. When normally it's real hard to get a late, 2.5 years after you're supposed to have an answer in, to get leave to put in a late answer. So I moved one to dismiss for failure to take a timely default. Now, there's case law in New York that says, well, you don't have to actually move to the default judgment in a foreclosure proceeding to get around that 1 year for filing for default, as long as you start moving toward it. So if you move your order of reference, if you've been in the settlement part, that tolls that. So the second thing I moved to dismiss, saying there was lack of jurisdiction, and put it down for a Travis hearing. I don't know how that's going to go. I don't know whether the process is good or not, but it was surprising that both the husband and the ex-wife both said, I never saw the papers, and we both lived together, and we never saw either one of the papers. So the third thing is that I moved for leave to serve a late answer. I have a feeling, that in the long run, I can't believe that the appellate divisions would allow foreclosures to take place on, and not allow parties come in to litigate these issues, even though it's been 2.5 years since the action was commenced.
There's actually a case that would help you with that, HSBC versus KO.
Yeah, I certainly cited that in my motion papers.
Yeah, it's my case.
Ah.
That's KATO?
Yeah, KO.
And what was that case about?
I was granted leave to file, compel them to accept a late answer 2.5 years after the foreclosure was commenced.
Because they failed to prosecute?
No, because negotiations actually were, in the mind of my client, were ongoing.
Yeah, in most cases, there's no modification. Oh, just ignore that and we'll do a loan modification, right?
They didn't even offer that. They fought me tooth and nail, and I went before Kramer, and I won the motion. It was mentioned in the New York Law Journal.
Now, it's surprising, though, that even when they're doing modifications now, they're still using the same mortgage and making MERS the mortgagee of the consolidations, even a year and a half after Silverberg. So I don't know what they're doing out there, these banks sometimes. Gee, I guess that's about all I have. Anybody else has questions? Because this is evolving every day. You have to try something new every day, as Davina says.
Why don't we talk about the bankruptcy issue? Because I know I didn't address that, but there's one of the bankruptcy, Lippold?
Yes, Lippold, that was to say that there had been a foreclosure proceeding, and they got their judgment of foreclosure. They then filed for bankruptcy. There hadn't been a sale, and they said, listen, it's too late to go back on a standing issue. Once the state court has ruled, we can't rule on it.
The other thing in bankruptcy that I didn't bring up that I said I wanted to address was that when you've got before foreclosure is filed and you've got, you put your client in bankruptcy so that they can extend the proceeding. Bankruptcy is one of the best places to litigate because of 3001 where they have, on your proof of claim, when they submit a proof of claim, that's when you start disputing it, right? Because if you can dispute it at the time that they file the proof of claim, let alone their motion for relief of stay, but if you can find it at the proof of claim saying that they don't have, they cannot prove that they have a right to have that claim, that's when you start. And under the new bankruptcy laws, I believe it was just this year, you can get attorney's fees and costs for litigating that. So do try to, if you've got clients that are willing to do the bankruptcy, that's one of the best places to go. I found because one, the bankruptcy judges will take the time. This is it's an adversary proceeding, so be prepared for that. But there's no additional filing fee for the adversary proceeding. You can do you can ask for attorney's fees and costs. So if you prevail, you can get that as well. And then you avoid the motion for relief of stay. And so what better place to litigate it than bankruptcy court? And bankruptcy court is one of the best places that decisions are coming out of. Arizona, you've got the whole decision here. Some of the best decisions are out of bankruptcy court. And those obviously another bankruptcy judge is going to take a look at, regardless if it's California. Because I don't know about you, but when I mention a California case in Indiana, they think that I've just grown antlers or something. Because they think that California is just way too liberal for them. But if it's a bankruptcy, if I can be in bankruptcy court citing another bankruptcy court, they will acknowledge it. It doesn't depend on the state.
I did cite Lippold because the bankruptcy court not only cited Silverberg, but quoted and followed it. Right. So now they've looked to the state law and they've recognized the sound reasoning for taking Silverberg for the second part.
So, but we will be willing to litigate that as an adversary proceeding from the very first time the proof of claim is filed.
All right, now let's see the case of Hernandez, HSBC versus
Hey, there was a couple of questions.
Oh, I'm sorry, I didn't see it.
Here.
I don't know. I had a question overall in general.
Here.
Mr. Hull, when you counterclaim quiet title, are you, as Ms. Westfield said, are you adding in all those additional parties that you found in your title search?
No, for one, I don't add in all the lien holders the way the bank would have to add them in as defendants in a foreclosure proceeding. Because as far as I'm concerned, those liens really don't affect the status of the validity of the first mortgage. So normally, I just said to this, I name MERS, and I name anybody who's signing a record of the mortgage. I certainly don't cite the original lender because they no longer have an interest. They got paid off the first day, so they don't have a law in this fight. So it's only MERS and those who are assignments of record.
So you do title searches to see who's got the assignment of record?
Right.
Okay.
But you do the original lender, Ms. West?
No, only if there's still if there's an assignment where they've already assigned, I only go to who's holding the current assignment. I try to keep mine as small as possible, and there was a question about that. So what if they answer it? What if I can't get a default? And what if they want to litigate it? Then I can do an amended complaint, and CFLA does great complaints that, that's where you put the kitchen sink, and you include all the parties, and you sue everybody. make a mess of it.
And then just on the standard of proof, proving the validity of an assignment of a mortgage. This is Second Department, only in February 2012. The affidavit from the plaintiff's servicing agent did not give any factual details of a physical delivery of the note and thus failed to establish that the plaintiff had physical possession of the note prior to commencing this action. So, you know, it's a little...
Can I have this out?
Sure, that is HSBC versus Hernandez, and it was just a slip opinion when I had it, but it was 2012 Westlaw 579706.
22 Westlaw?
2012 Westlaw
2012.
579706.
579.
I wouldn't be surprised if it's reported by now.
That was decided, or the decision date was February 21st of 2012.
Now, I do encourage everybody to take the time to read the two motions on Alderazzi, because that's going to give you the really understanding the reasoning that would led to Silverberg and why they don't have the power to assign. And see, Alderazzi, the first decision was, let's see, 28 miscellaneous 3rd, 376. And the bank came back again and tried it again. And that was, I only had a slip opinion on that one, I believe. Yes, that's the case. Is there a site on there? Yeah, 31 miscellaneous 3rd, 1209A. And that's really the detailed analysis. And that's the way you're going to want to argue in the other states, is that the MERS does not have authority to act on behalf of the lender in the way of assigning mortgages without.
Page 3 of that site, they talk about the MERS agreement, and that's where he was saying that the MERS agreement among the bank and MERS doesn't cover the ability to transfer.
Yeah.
So,
one, that doesn't cover the ability to transfer it, and two, they specifically don't take an interest, financial interest in the note. And those are the two linchpins of the problem with the chain of title.
how can you transfer a note if you never had a financial interest in the note?
Right. So they can't. And I've seen attempted assignments by MERS to assign both the note and the mortgage. They can't do that. I've seen cases where MERS assigns the mortgage to one servicer, and 2 years later there's another filed assignment, and they never got it back.
Well, that's just like the one I was talking about today, that I bought the mortgage and it's been transferred 3 times by MERS without ever bringing it back. And that's why it's basically a kind of a junk bond that you can buy from Seattle, and hopefully I can just...
And the question is, are all the banks listed in the assignments of record, so proper party defendants, or is only the first one? There's no recorded assignment back.
The problem.
Yeah.
Big problem. Yeah.
If you have any cases where the assignment was, what's called Robo-Signing, be it fraudulent, be it fraud, reason, but essentially the assignment was fraudulently signed.
Sure, lots of them.
Yeah, they're out there. I haven't seen them, but I.
That's when I was arguing in Indiana that there was no apparent authority or actual authority. That's why I said that the two key words for today, standing and authority, right?
Right.
Because if you don't have actual authority, because you're an officer, and that's where I was going back to, read your corporate statutes, because a lot of times you have to have, in Florida, there's only certain officers that have the authority to sign.
Right.
And you have to show that they're actually employed. You can't just say, you 100 people out there, you go sign on behalf of MERS. You can't do that.
No, I mean, in this one particular case that I'm dealing with, I mean, it's very blatantly obvious that that person I don't think even exists. In fact, actually, I reported to the police manager's office. They're actually using it in their case against nationwide title of Florida. So, in that specific mortgage, seeing as that assignment I'm assuming is going to be null and void, and the prior bank that assigned it is defunct, then it should just be.
You know, when I started coming out and talking about a quiet title a year ago, it's because if no one can prove they own the mortgage and the prior bank is defunct, who can claim the mortgage? You know, if they haven't done it properly. So that's.
And the current servicer cannot come back and try to get the money on the.
The servicer doesn't own it. You have to, you know, in it's good to use the bankruptcy court, and I think it was LaPole that talked about who is a creditor. And they define a creditor as a person that either owns the debt or has, how do they define it? Owns the debt or has a right, has permission from the actual.
The holder to collect the debt for them.
Like an agent. Not a nominee, but an agent.
So would the servicer be the agent then?
I don't believe so. I don't believe that they're saying that you can do
I've
that.
heard something like that.
I've heard that,
They
yeah, the
have the
servicer
proper
can be an
authority.
agent, but I'm sure that that's so.
Yeah, I've even read in a case that even though you don't have the note, you can foreclose if you are an agent of the holder. I don't remember the site, but I read about it and I have.
In reality, they base that on UCC. I believe in the definition of the holder, it has the actual holder or someone that has the authority of the holder.
Right.
Okay, so it is, if you have under an agency situation, in which the authority is given by the actual holder to them. And then they have even a situation in which a non-holder that has the right of the holder can go ahead and enforce the note.
Obviously, what's your first question though on discovery? Show me in writing where you've got the authority. Right. So if you're not the actual holder, you make sure you get discovery on that.
The authority to commence the foreclosure.
Right. Right. Show me where you were conferred authority to commence foreclosure.
Well, going to that whole issue of the authority, and maybe I wanted to know if you had any experience with this, or maybe somebody who does more of bankruptcy can answer the question. Right now, I'm doing a case in Richmond County where the lender filed for bankruptcy, and the plaintiff produced an alleged agreement giving authority to assign after the bankruptcy. But my impression was the minute the bankruptcy, that lender filed for bankruptcy, all agreements vanished or were
Because the
null and
trustee
void.
becomes the owner.
Yeah, right.
So-
I mean, that's how bankruptcy works. You have no authority, outside authority, other than the trustee.
So,
Once you file bankruptcy, all your assets, all your estate, who do they belong to? The trustee. And I think one of the cases addressed that, didn't they, in New York? Am I wrong about that? I can't remember.
I'm not the bankruptcy guy.
Yeah, but that's why I like bankruptcy, because they're saying that if you're filing bankruptcy, if for example, if a company had filed bankruptcy and they own a mortgage, and then you see a mortgage later being transferred, okay, transferred outside of the bankruptcy during the time,
No, it was after, it was New Century.
okay,
Filed bankruptcy, I believe in 2006.
right?
And now Carrington is produced on an assignment that I compelled discovery, produced a power of attorney
Was the bankruptcy still pending? Go back to Pacer.
And I don't know.
Go back to Pacer, research it, see if the bankruptcy was still pending. A power of attorney would be ineffective during a bankruptcy still pending because the trustee would be the only one with authority.
And of course, a standard power of attorney is not going to work for MERS either because corporations can't act by power of attorney, only individuals.
Oh, repeat that?
Yeah, corporations can't, only individuals in New York can use a power of attorney. Corporations can't act by a power of attorney.
So-
They have to convey their authority in another way.
So where can I find an actual form like that? Where can I see that? How does, you're saying that there's a special power of attorney?
Yeah, I'm just, no, I don't know. I'm just saying that they can't use a standard power of attorney in New York because only individuals can act by power of attorney in New York. I have not seen what the form they use, but again, they have to have some further authorization of MERS to assign the mortgage above and beyond what's in the mortgage.
A written authority.
agreement, consent. Oh, got you.
Like a secretary.
Got
You
you.
see, the banks, it's usually something that the bank's attorney will draft up on their own. It doesn't follow any particular format, and it normally it's signed off by the VP.
Yeah,
The
the normal
argument
procedure.
should be that
Yeah,
it's
sure, like one sentence.
the board of directors or the minutes of the shareholder, something like
Yeah. It would have to be, because you have to.
What do you got?
No, that's separate. You have to get the corporate resolution to show that the power, the person who's signing off on the power of authority has authority to sign off on it.
But just remember that if that bankruptcy was pending, and you can always check that in Pacer, pacer.gov. You can go in and you can check the bank. If it's still pending and hasn't been discharged, only that trustee had authority during that time.
There are two methods that they use for the purpose of assignment. One is the authorization by someone like MERS telling that a vice president or someone that is working there can sign the assignment and make the assignment. And the other way is by power of attorney. And power of attorney, I don't know, it requires that it is filed with the county clerk in order to be effective. You cannot have in real estate transaction, at least in the state of New Jersey also, if you don't have a file, it is not a valid power of attorney. And it has to be attached to the document. So you cannot have somebody that you leave a power of attorney and then has an assignment, and that has that assignment recorded without having the power of attorney attached to the assignment. So those are the two methods. In reality, the power of attorney one is the one that they use less. The one that they constantly use is the authorization directly from MERS to someone outside MERS for signing the assignment.
But remember, that's a discovery issue, right?
Right.
So it's going to be discovery, do the production of documents, do the admissions, try to get them to admit that they didn't have, that somehow that they were never employed by MERS.
But if the bankruptcy had already been discharged or terminated, then it's still any agreement would have been voided anyway.
Well, if it was.
You're saying that if it was during the pendency of the bankruptcy,
Right.
the trustee would have had to have signed any agreement.
Would have had to approve.
How about at the end? That means,
After it's done.
yeah, no one could have signed it.
Well, it depends whether the corporation still existed.
Yeah. I'm sorry?
Did the corporation still exist?
No, New Century.
Right,
doesn't.
so no
There's
one
nobody
has
going to
that
sign it,
authority.
it's over.
And yet, that's where the problem with MERS comes in, because if Old Century never existed after that point, MERS doesn't have authority as a nominee. And that's the problem.
Sometimes these companies, though, what they do is within a bankruptcy estate proceeding like that, what they would do is they would try to buy some of these assets from the bankruptcy estate. So it could be that maybe like a vulture fund or something like that went in, purchased it, plucked it out with permission of the trustees, and they want to check that.
Yeah, but then the trustee would have to sign the assignment.
Yeah.
Yeah, the trustee would have authority to sign.
Everybody involved would have to have received those papers.
Definitely wasn't signed by a trustee.
Was not
Was
signed.
not signed.
I mean, there's only so many trustees. There's only, particularly on I'm assuming that's an 11 or something, right?
I'm sorry?
Was it a 7 or an 11 trustee?
No, it wasn't signed by a trustee. They just produced some agreement.
And that's where you've got to think, whenever you analyze any of these cases, think, did they have authority? Did they have standing? Authority or standing, authority or standing? Because it's usually you're looking either at documents or do they have a right, you know? And those are the two questions always, authority and standing.
Do you know if the case was Chapter 11, Chapter 13, or Chapter 7? Was it Chapter 11 that was converted to Chapter 7, and then there was a sale of the asset? If there is a sale of the asset, the trust, the bankruptcy court order the sale, and a third party can obtain it, and then he has the right over all of those assets, and he can assign it. So you have to find out.
Yeah, and that's where you go back to PACER and do your research.
Gotcha.
That's a cheap way to do research on PACER.
Yeah, I certainly will go into e-courts once I get an assignment of a judge, and I will go through the docket on e-courts and see which matters inside of a judge or foreclosures, and then I will go in and look at the motions and the decisions to get an idea of where these judges are coming from.
Do you get a right to do an automatic change of judge or not?
No.
So at least you know what your judge is dealing with.
Well, I was going to just say, in bankruptcy with federal court, I think what we need to do is look forward to a letter. I mean, if it's like there's some prejudice or something left in my case, then it's not really hard to change judges. In state court, there's the same method, but I think it's a little bit hard.
I've had somebody suggest that you automatically start a committee against the re-election of any judges that are against the mortgagors, and then you move to recuse saying, I'm a member of this committee. I haven't seen it tried yet, but I've heard people discuss it.
I think you better have a pretty good paying client if you're going to do that. Because you may never appear before that judge again. I mean, that's the issue in that particular case.
You got some? Yeah.
My question is more simple than the bankruptcy law. I'm sure you guys are already knee deep in it, advice or what have you. My question is, before these banks tried to storm the gates, and we have a defense to work with them, is it your contention that after we have discovery and we know where all the failings are, et cetera, that we should file suit, or
This is in a foreclosure?
it's in a foreclosure case?
Okay.
We should file suit, or should we first send a letter that says, listen, you guys are really, really way out there. This is kind of why we have, these are the top 8 things that we have among the 17 that are actually possible.
Anybody get a response on any kind of letter from this? File a suit. You don't even have to go into it. I got no responses. I did not get responses on any of my, I had beautiful, like I said, I researched that demand letter up and down. Beautiful demand letter, got nothing. File a lawsuit. You know, you got to have a position. You got to have some leverage, and your leverage is a good faith suit on whatever your position, if it's quiet title or if it's whatever.
There are positions where I would recommend, I've got a case that they finally foreclosed about 4.5 years after they defaulted. They send the 90-day notice, and it doesn't even come close to looking like New York statutory. So I'm putting in my answer, and I'm going to wait 1.5 years, and I'm going to move to dismiss, and the statute's going to have run. And there are a lot of different ways than just only standing issues to beat this.
Yeah. When a client comes to me and they have had a case that's been ongoing, and in Florida it's a 5-year statute. So, you know, if I'm conferring with our managing partner there and I'm saying, look, don't even touch this. Don't touch it. Just let it rot. Because we want the 5 years to run. Because then they don't even have authority. After that statute of limitations, we go in, we ask for a motion to dismiss based on failure to prosecute and statute of limitations.
So does it make sense to sometimes just wait the 6 years?
Sometimes it makes sense to wait, typically when
When
it's a sleeping dog, don't wake up a sleeping dog.
Like, do not trigger that.
Yeah.
They don't commence a foreclosure. I tell my clients, just sit back and wait and let them pay your taxes and your mortgage insurance, or your taxes and your house insurance, and then wait the 6-year statute of limitations to run, and then under RPAPL Article 15, it could be just quickly waived.
How about they not commence foreclosure and they just stop and sit there?
This gentleman over here just told me that Nassau County now has a mortgage foreclosure dismissal part. And if you haven't moved your case in a year, they'll just dismiss it for you. Is that right? We don't have that in Suffolk. Now, I'm making motions for failure to prosecute or failure to take it to
Yeah, if it's post mediation and they haven't properly gone through all the stages, gotten the order of reference, filed the affirmation, and all those things, it automatically gets put on this. And I just started seeing this recently. Automatically gets put on a mortgage foreclosure part, dismissal calendar, and literally they sit in a room. It's an attorney, the same. For some reason, Rozicki represents every single bank when it comes to this particular thing, and essentially sits there with a stack this high and a referee and a clerk, and they say, we gave you the letter. They send out a letter that says you have to have done X, Y, and Z. The referee says to them, have you done X, Y, and Z? No. Okay, thank you. You'll be getting a decision in 30 days. And they basically say, we just have to let you know they're probably going to recommence the action because it's being dismissed without prejudice. But especially in New York, it's like Florida where, foreclosure takes 3 years. You know what? There's another 3 years. And not to mention, like the one that I went to last week, this is a new client. And it's been sitting around since 2009. I don't have to even worry about my motion to file an untimely answer because they're going to have to restart. And I could start from scratch, which is great for me.
Even better, isn't it?
Yeah.
Because the farther you're away from them signing those documents, the more likelihood that they've lost everything.
Right. One thing I forgot to tell you, I mentioned briefly, is this Real Property Law 329. Actions to have certain instruments canceled still with record.
That 329?
Yes. I combine this with a declaratory judgment action, my quiet title. And it says, an owner of real property or of any undivided part thereof or interest therein, or an owner of rent which will accrue from a tenancy or subtenancy thereof, may maintain an action to have any recorded instrument in writing relating to such real property or interest therein, other than those required by law to be recorded, and that's the key language here, or any recorded assignment of rent from a tenancy or subtenancy of such property or interest, be therein declared void or invalid, or to have the same canceled of record as to the said real property. Now,
what statute?
I'm sorry, what's that?
Real Property Law 329. I went through because I was trying to figure out how do you do the quiet title, and technically a quiet title action was denominated that in the Real Property Law. Is really, they're conflicting deeds. And this looked to be the proper section for canceling the mortgage. So I put this in, I put a second cause of action, which is a common law cause of action, requesting the same relief, and then the declaratory judgment action. Now, I just got a motion to dismiss on one of these based upon MERS versus Romaine, saying, oh, this is an instrument that is required to be recorded. And I said, that's not what that case said. The court said the clerk had to accept it for to be recorded, but it wasn't required to be recorded. And he's also claiming there's no judicial controversy. I don't know where that came from. It doesn't say anything about residential, so I'd say any real property, it says. Owner of real property.
So in your counterclaim, you're putting in a counterclaim, quiet title. You're asking for a declaratory judgment and a separate count for under the RPL 329. Three different.
Right. So even if, let's say, they do determine that my statutory cause of action is invalid because it had to be required, I still got my other two causes of action, and I'm sure the court can act in equity. No, this is Real Property Law 329. All right, then. Oh, it was just a common law cause of action, just alleging the same thing, but not under the statute.
Just a basic quiet title claim.
Yeah. And I'd make it pretty bare bones too.
The common law cause of action is based on what?
Well, it's just saying, number one, there's a that you own the property. Number two, there's somebody out there that claims to have a mortgage and a mortgage that is against the property. It's a matter of record. And what I have to do, you have to come up with a reason. The guy that came to me, he said, I just want to sell the property. So I said, that's why we have a traditional controversy. He can't just sit back because you're not foreclosing. He wants to sell this property, and it's an unreasonable restraint on alienation of real property. So, and then I say, that the mortgage is invalid, that they have no standing and they don't own the mortgage, and we'd like to have it canceled as a record so we can sell the property. Will it work? I don't know, as I say, the first time I used it, they re-offered $515 down to $280 on the first offer, so it seems to have some effect.
What's the current value of the property? They went down to $218.
$325, I think.
So think about that. I mean, that's a really
This is
good
leverage.
reduction.
This is real leverage.
Yeah. To me, that's something to really think about.
Thank you very much. It's been a pleasure to be on the other side of this.
I think that's it.